Good morning. We're here on our March 21st miscellaneous docket. Mr. Sanders.
Good morning. Rusty Sanders on behalf of Charles Allen Holly. May I approach with a plea?
You may. Thank you.
Mr. Holly is withdrawing his previously entered plea of not guilty and entering a plea of no contest to one count of battery, and I put the statute number, that's the battery on an EMT officer. And the terms of the plea and sentencing is that he is allowed to enter into a PTI, a diversion program, that upon successful completion thereof, the case will be dismissed, and if he does not successfully complete, the court will proceed to sentencing. That PTI was entered with officials a couple months ago, and he's prepared to check in today after court. And you have the fully executed copy before you, Your Honor.
Very good. Mr. Holly, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
State an agreement.
Yes, Your Honor, that is a statement of difference.
Is there, do we have a sentencing agreement? Not sentencing.
We do not have one.
Okay, you can put your hand down. Do we need to have a guideline?
score sheet?
Score sheet, yeah.
No, Your Honor, that would be
Because it's just
for
because
sentence.
of the PTL. Okay. So, Mr. Holly, you heard your attorney state the terms of your plea agreement. I see that same plea agreement is reflected in your, it says an offer of plea, but it's really a plea agreement. Your signature's on the back of it. Have you gone over this in detail with your attorney, make sure you understand the ins and outs legally of your plea agreement here today?
Yes, sir.
And you understand, importantly, that this is a final resolution of the first part of the process. Because if you don't, importantly, what you need to understand is what's laid out very clearly here, that if you don't complete successfully your PTI, the pretrial intervention program, there's no reason why you shouldn't, but if you don't, you come right back to sentencing. You don't get a chance to then fight your charge and say, oh, none of this happened, blah, blah, blah. You understand you're kind of giving up that right on this by entering into this plea agreement.
Yes, sir.
You believe it's in your best interest to do so?
Yes, sir.
Nobody threatened or forced you to get you to enter into this plea?
No, sir.
You did so knowingly?
Sir?
You did so knowingly, you understand, you had all
Yes.
your legal questions answered by your attorney?
Yes, sir.
Very good. Based upon that, the court will accept the plea agreement as set forth, and we already have the CPI has already been
Yes,
accepted? Okay. So, basically, the court's accepting the plea agreement. You'll continue with the PPI, hopefully to success.
Thank you very much. That's all I have.
You have a good day. Yes,
You
sir.
too.
Your Honor, who's going to file the PTI?
Miss, you have it, Miss.
Thank you.
Yeah. We'll make sure that's done directly. Thank you. Thank you.
Mr. Kilpatrick.
Good morning, Your Honor. I have Erica April 14. She is in custody.
Okay.
Good morning, Your Honor.
Good morning.
Your Honor, Ms. Cortez is before the court in two case numbers, 16 CF 2347 and 20 CF 563. We filed a bond modification.
I've got a third one also.
Yes, Your Honor, she's already got a signature bond on that case number. I
Okay.
found out from Madam Clerk, so that issue is moot at this point. But I have had an opportunity to speak with Ms. Sharpless. We have an agreement in those two case numbers, if I may announce it.
You may.
Your Honor, in case number 16 CF 2347, it's a 2-count information. On each count, it would be a $5,000 signature bond for a total of $10,000.
So what you've had an agreement is, you're not entering a plea, you're entering an agreement on the bond.
On the bond modification, yes, sir.
Entering into an agreement on a bond doesn't get you there.
Oh,
That's not by agreement. You guys can present it to the court, you can offer it, the court's gotta make that call.
yes, Your Honor, this is a situation where,
Are you asking the court to accept that, or?
Yes, Your
This is
Honor,
not
we
just
are.
a plea agreement.
it's not a plea
You gotta
agreement.
articulate why it is that it's being entered into.
Yes, Your Honor.
Once they said it, then it falls into my lap, so I've gotta have some oversight on it.
Understand, I'm going to give you the reasons why the
Okay.
state would be inclined to agree with the defense in this matter.
Great.
This is a situation when Ms. Cortez was on probation. She did violate that probation by essentially, lack of a better term, picking up a new charge of a possession of a controlled substance without a prescription. We have since, I've talked with my client and spoke with her and subpoenaed her medical records. She has indicated that she had a prescription, she just didn't have it on her. It was one pill that she had, it was in her storage unit where she was moving some stuff and it was in her possession when she got pulled over. And so with that being proffered from the defense, the state feels uncomfortable with my, I guess, testimony of that being the situation, but it's just going to take a little bit to get her, get the records. She has no prior violent crimes. They're all drug related as far as that goes. But we're proffering to the court that she did have a prescription at that time. I'm in the process of getting those records. Obviously, the court knows that that does.
So what's the specifics, so we can make sure on the record of your
Proposal?
bond? Yeah. the
Proposal?
bond.
Yes, Your Honor. And to keep the organization and organized for the clerk of court, 16 CF 2347, it would be a $5,000 on each count, and that's to run concurrent.
5,000 signature? Signatures?
Each count,
Okay,
yeah.
Each count.
Yes,
I didn't, you said 5,000, I wanted to add the signature.
yes, ma'am.
Okay, I
Yes.
knew that's what it was, but I'm trying to get the record straight.
Yes,
Go
sir,
ahead.
perfect. And then in case number 20 CF 563, it's just 2-count information, so it'd be 5,000 each count concurrent, so it'd be a $10,000 signature bond.
Okay, actually, it's two $5,000 signature bonds.
Okay, understand.
Stay in agreement with that?
Yes, Your Honor, that is the state's understanding, and prior to this probation, which are all possession type charges, she had one prior misdemeanor, and that's all she has, Your Honor, so.
And for the record, I agree. And as I was looking at this, this is a case that court agrees that it should be a signature bond.
Thank you very much, Your Honor, thank you.
Sorry for the confusion.
Oh, no, not at all. And that's my case.
That's all you got today.
Yes, sir, may I be excused?
You may, thank you.
Thank you so much, Judge.
Mr. Rich.
Good morning, Your Honor.
Good morning. Hold on a second, let me just.
Yes, Judge.
Mr. Kilpatrick?
Yes, ma'am.
Because your client's gonna get out of jail presumably on these signature bonds?
Yes, sir.
She'll be on the next pretrial on the 10th of April versus the 12th of April. So we're changing that. Just make sure she knows that.
I will let her know. Thank you so much,
Thank
Judge.
you. Thank you. Mr. Rivera.
Good morning, Your Honor. David here for Mr. Christopher Goins in 22 CF 3123. We're here today before the court for a motion to modify bond. As condition of his bond set at first appearance, Mr. Goins was ordered, among other things, GPS monitor, house arrest sanctions, and no unsupervised contact with children. Mr. Goins and his wife have 3 children together. At the current time, Mrs. Goins is the primary earner for the household. While she is working, Mr. Goins is required to stay at home. He's the primary caregiver for the children to watch them. Given the bond conditions, the families had to go through extreme lengths to have other family members stay with him, to make sure he's following the bond conditions. His wife is here, prepared to offer her testimony today, but there is no objection from her, obviously, to allowing her husband to continue to care for their children unsupervised and lift that burden on their family. Additionally, I've spoken with pretrial. He's had no violations or issues while he's on probation. They are paying a fee, but there are one-income households at the time. We would have
Sorry, since he's been on probation?
or he's been on pretrial release, Judge.
Okay.
He is not on probation. On pretrial release, we would ask the court to consider modifying to either remove the GPS or remove the house arrest sanctions. We're not asking the court necessarily to remove both of those sanctions, but to give him some relief for at least one of the two while he's staying at home watching the kids.
So the GPS and what?
The default conditions were house arrest, community control sanctions, and GPS monitoring. Typically, I'll see as a default condition, GPS is fairly common. I'm kind of surprised at both in this case. Actually, pretrial originally didn't even have him under that house arrest control. They had him on GPS upon release. And then they figured out they made a mistake. They weren't actually monitoring him that way. They added that condition because they caught their typo, but it wasn't because there were any issues they had with Mr. Goins. So he's already demonstrated full compliance with bond conditions up to that point.
What's the state's position?
Your Honor, it does appear that Judge Schlechter at first appearances did order the GPS and the house arrest. It just wasn't imposed, so that was actually a condition that should have been enforced. The state does not necessarily have a problem with releasing the house arrest condition, but we do believe the GPS is important given the nature of the charges. Your Honor, the defendant is charged with soliciting a 14-year-old online, also sending an image of his penis. Based on that, we do have a concern as to him having unsupervised contact with the minors. We believe that condition should remain in place given the nature of the charges.
And regarding the unsupervised contact with his own children, Your Honor, Mrs. Goins is present. Would the court like her to offer her testimony regarding that, or would the court accept my proffer that she has no objection? Certainly allow her husband. Thank you, Judge.
The court will grant that remove the house arrest portion as the state. The court's going to maintain the GPS monitor. I think we're too early in this to remove the no contact order, no supervised contact. Supervised contact is allowed with his children, so I'm going to maintain that.
Thank you.
Understood, Your Honor. I'll prepare an order for the court.
Thank you.
And that's all I have, Your Honor. If I could be excused.
You may. Thank you. Ms. Reed.
Good morning, Your Honor.
Good morning.
I'm covering one case for Mr. Byron Cotton. That's Leah Fischels Clayton, 20 CF 3126. Miss Fischels Clayton was on for last week. We kept her on this week for status. She's a PTI recall. She has since either completed or paid all of those outstanding obligations. I have confirmed that with probation as well as provided proof to the state, so I just believe the state has an announcement.
And Your Honor, I have received confirmation that Ms. Fischels Clayton has completed all the terms for PTI, so this case should be dismissed.
Very good.
Okay. Thank
We'll
you.
do so. Thank you.
All right, thank you. That's all I have before the court. May I be
Thank you.
excused?
Yes, ma'am.
Thank you, Judge. Okay, go.
Mr. Arrowwood.
Morning, Your Honor.
Mr. Arrowwood, what do you have? I don't have you on here.
Judge, you moved, we had court last week. I have a Micah Hagan, 2019 CF 423. You gave the state a week to try to get in contact with the victim in this case to see if there was any objection. You wanted to
I
grant it.
remember that, but not on the document.
Oh, Okaloosa was the original.
Hold on. Thank you. I'm just trying to find it. Okay. Yeah, you got to do a notice of appearance.
Oh, yes, sir.
Thank you.
I'm sorry for the.
No, I'm glad you corrected this.
No, that's all right. I just have to find it on my docket to keep up with it.
But did you give the state till today to try to get in contact with the victim? Well, we believe that the victim is kind of absent in herself from the state, so we don't believe that the state has been able to contact the victim, but.
We were able to contact the victim, Your Honor. She
Okay.
objects to the modification.
Okay.
But otherwise, the state is prepared to proceed with argument, so.
You may.
Okay, so Your Honor, Mr. Hagan is before the court asking the court to early terminate his 5-year term of probation. That term of probation is for a felony battery that was pled down from a sexual battery. The allegations in that case are that the defendant sexually battered the victim after she declined to acquiesce to his sexual advances. She specifically alleged that in the course of the battery, that along with vaginal penetration, the defendant slapped and strangled her. Mr. Hagan has already received a significant benefit in this case by virtue of the fact that he was placed on probation with a withhold of adjudication. If the court reviews the sentencing memorandum in this case that was filed by defense counsel, that was argued for vociferously, apparently, so that the defendant could actually receive the benefit of the withhold with his probationary sentence. Specifically argued in the sentencing memorandum was the mental health struggles that Mr. Hagan has faced. My primary argument for the court today to deny the motion of the defendant is that probation ensures that the defendant continues to receive any needed treatment or medication management in relation to his diagnosis, which is referenced in that sentencing memorandum at length, and serves to protect the community from potential incidents like this in the future. Specifically, my argument for the court is that the comparative burden on Mr. Hagan of continuing to be on probation is minimal compared to the benefit that our community continues to receive in relation to the protection from Mr. Hagan being serving the entirety of his probationary term. My office was able to contact the victim in the case who did not wish to be present in court, but stated that she does not think that the defendant should be able to terminate his probation early because of what he did to her. He already entered into a plea agreement, and she is disappointed that he's trying to end his term early.
Mr. Arrowwood?
Judge, we believe.
I actually should have let you talk first, but go ahead and detail. I've read through your motion. I have a couple questions, but I'll let you kind of begin first.
Judge, we believe that my client was overcharged to begin with. Depositions revealed that he was overcharged, and that's when the state decided to lower the charge and allow my client to plead to a felony battery instead of he was alleged to have occurred. My client has completed halfway of the probation term. He's paid everything. He's completed his psychological screening and counseling. He's still going through counseling. Contact was made with his probation officer, Tiffany Rose. I presented the court with a email from the probation officer, Rose, who stated that she has no objection. He's had no violations. And I would submit to the court that if anybody knows Mr. Hagan better than the state or myself, it would be the probation officer that's had monthly contact with him and made sure that he's complied with all the requirements of probation.
You state in here the defendant has completed every condition and has gone far beyond the requirements of his supervision. What do you mean he's gone far beyond the requirements of his supervision?
He's paid everything ahead, Judge, and completed all his counseling.
So is he continuing to be with mental health
Yes, Your Honor.
counseling?
Yes, Your
When
Honor.
you say he's completed it?
He's completed, well, he's still going through that. He's completed what he had.
hasn't completed it.
Yes, sir. As far as he hasn't been excused from any future counseling, he's still going through counseling.
I was ordered by the court, Your Honor, to get a mental health evaluation, which has been completed, and that was the extent that I was aware of. I still take my medicine, but as far as any other, I've completed the mental health evaluation.
So the mental health evaluation didn't suggest any follow-up counseling or anything?
No, sir. It's turned into my probation officer.
It's the state?
I'm sorry, Your Honor, what is your
Information
question?
regarding that? Well, I was just wondering whether, there are, the mental health evaluation, he's basically saying he didn't recommend any.
I'm unaware of the specifics of what came back from the evaluation.
The court has a discretion to terminate. The court's not obligated to do so, and the court does take into consideration all the things, including the charges, the probation plea agreement, as well as, importantly, the views of the victim in this case. Based upon all these things, the court's going to deny the early termination.
Okay. Thank you, Judge. That's all I have.
Mr. Durrell.
Yes, Your Honor. May it please the court, Justin Durrell. Your Honor, this is Connor James LaRose on the docket, 22 CF 964. President approaching, Your Honor. We do have a written plea agreement, if I may approach.
Yeah.
Thank you, Your Honor. Your Honor, at this time, Mr. LaRose would withdraw his previously entered plea of not guilty, enter a plea of no contest to counts 2 and 3, the understanding the state is dismissing count 1.
What's BDIC?
Basic driver improvement course, Your Honor.
Okay.
That's how it was on the plea form that I received, Your Honor. I just put it right on there.
Is the state in agreement?
Yes, Your Honor, that is the state's agreement.
Mr. LaRose, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes. Okay. So, you can put your hand out. You heard your attorney state the terms of the plea agreement, correct?
Yes, sir.
And I see that those same terms are contained in the written plea and sentencing agreement that you have also signed. So have you read through this plea agreement? Yes? Yes?
Yes, sir.
And have you gone over it in detail with your attorney?
Yes, sir.
Just want to make sure you understand what you're doing here, because you're giving up some valuable legal rights by entering into this plea agreement.
Yes, sir.
And the legal rights are the right to have the state prove their case, the right to confront witnesses. All those things are being waived in order to enter into this plea agreement. You understand that?
Yes, sir.
And you had all your legal questions answered about the plea agreement?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement?
Yes, sir.
Okay. And importantly, there's no contact with Mr. William Broxson, as well as $500 restitution that must be paid during the term of your probation. Do you understand that?
Yes, sir.
Okay. And you understand that this no contact is one-sided. It's your obligation to stay away from him. So if he walked up to you in public, you'd be in violation. Do you understand that? You got to stay away from him.
I don't even know what he looks like.
Okay.
Yes, sir.
Very good. Okay, the court will accept the plea agreement as stated. Count 1 will be null pros. Count 2 as charged, 6 months probation, and count 3 as charged, 11 months, 29 probation. It'll be by JCS, correct?
Yes, Your Honor.
Okay. Very good. Standard fees and costs. No contact with Mr. Broxson, and restitution to Mr. Broxson.
Thank you very much, Your Honor.
Good luck.
Madam Clerk, do you have a card for Jason?
No, sir, but he may have one in this first row.
Okay. Thank you.
He may have a contact with them. I'm sorry.
That's okay. Thank you.
Jennifer
cost.
Flowers with RCC.
I'm thinking that the costs are going to be the $300 with a $65 down, the misdemeanor cost.
Yes.
That's not the felony 515.
That's right.
I just wanted to be clear on that.
Thank you. Thank you. Good morning.
Sorry,
Would
good
you
morning.
announce?
Yes, Jennifer Flowers with RCC. I'm covering for Rudy Harper. I have, I think, just two on the docket.
Hold on a second. Let me get to that. Okay.
They're both inmates. Cornelius Donaldson is a bond hearing.
Very good. Can we bring out Donaldson? What's the other name?
Flaglier. Faglier.
Counsel, you may.
Yes, Your Honor, this is Cornelius Watts Donaldson. We're here today in 4622 CF 1617 on a motion to set bond. Your Honor.
I've reviewed the motion, but go ahead.
Yes, pursuant to the motion, just basically, he was given a no bond at first appearance due to a violent felony offender of special concern designation, but that has since been confirmed that is inaccurate. He is not a violent felony offender of special concern at all, and he is not on supervision. So even if he were, he would be entitled to a bond. So, Your Honor, we're asking the court to set a reasonable bond in this matter.
State.
Your Honor, that is correct. I did confirm, I checked the score sheet that was previously provided to the defense. It had only misdemeanor offenses on there. I mean, there were quite a few, but there were no felony charges even on there. I did go back and recheck the criminal history to make doubly sure. He has no prior felony convictions, Your Honor, so he definitely does not meet the criteria for violent felony offender of special concern designation. Your Honor, he isn't entitled to a bond. The state is asking for a high cash or professional bond on each of these counts, Your Honor. The co-defendant the co-defendant, which Your Honor has also heard a bond hearing on, received a $10,000 cash or professional bond on the kidnapping charge and a $15,000 cash or professional bond on the robbery charge. Your Honor, the state believes that Mr. Donaldson should get at least what his co-defendant received on those two charges.
Was the co-defendant charged with any of the other similar charges than this defendant?
Your Honor, that's a little bit confusing. I believe it was done by direct file information, so yes. But the ones that were showing on the jail website were the two kidnapping and robbery charges. Your Honor, the evidence that the state has is that Mr. Donaldson was actually the person who planned and orchestrated the kidnapping and robbery of this victim. The co-defendants were principals to this incident, Your Honor, so I believe that Mr. Donaldson should receive at least $10,000 cash or professional on each of these counts, Your Honor. And I did speak with the victim, Your Honor, and the victim could not be here today. He did understand he is entitled to a bond, but again, we're asking for a high cash or professional bond on each of these counts from the court.
Ms. Flowers.
Your Honor, I would ask for, I understand that these are serious charges, but they have to be proved. Again, he is entitled to a bond, he is indigent.
He doesn't have the means to afford a very high bond. As the state mentioned, he only has misdemeanors in his priors. I would ask for, something in the realm of 5,000 cash or professional.
Okay. Well, based upon the state's acknowledgement that he is not qualified for the violent felony offender of special concern label, he is eligible for a reasonable bond. The court will issue the following bonds. On the aggravated assault with intent to commit a felony, court's ordering a $25,000 cash or professional. The kidnapping and the obstructing justice and the theft of a firearm each would have $10,000. The grand theft is a $5,000 cash or professional, and robbery with a firearm is $15,000. So, let's see, that's $75,000 total. Cash or professional.
Thank you, Your Honor.
Next is, take a shot here, Faglier.
Faglier or Faglier, Your Honor?
Fagler.
Fagler. Okay. Do we have, do we want to address Darius Wilson?
I told him that,
Okay.
if you want to tell the judge.
Okay, Your Honor, Darius Wilson was showing up, that he was transported, but I believe Your Honor signed a order to continue, so we weren't gonna bring him out.
Okay,
That's-
very good.
So we can.
It was continued to what is he?
I just got that it was signed yesterday.
Would it continue to what date?
We requested 4/12,
Okay,
so.
very good.
Your Honor, is there Fagler? Okay. This is Joshua Fagler, and we're here in 22 CF 1227. We were recently appointed on this case. He has a new law case, 23 CF 404, set for the April pre-trial conference. So we're asking to continue this VOP to that date to possibly resolve both.
Okay. So is this the first time up on this violation?
Yes, and we would enter a
Make
denial.
plea? A denial?
Yes, thank you.
Mr. Rogers, anything on this? You're just standing like you wanted to say something.
Oh, no, Your Honor, I'm just standing to let you know who the prosecutor is, that's all I
We'll
know.
enter a denial, and we'll run it with the other case, so we'll come back on 4/12 for the next pre-trial. Okay?
Thank you, Your Honor.
Thank you very much.
That's all I have today. Maybe it's-
Thank you.
Thank you.
Mr. Powell? Good morning. Good morning.
Bo Powell for the record on behalf of Keith Golden.
Judge, could the state now approach, please?
Sure.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Is there a waiver on file for him also?
We did file, I believe we did file a waiver of appearance, Judge. However, is this
My case, yeah.
I believe there is a order to take into custody on this matter. And so I've advised him to turn himself in. I just wanted to let the court know that.
It's my understanding as well, Your Honor. We were actually here on this case last week.
Mr. Parnell had covered.
Yeah, so there was coverage last week. It's my understanding that Mr. Rivers sent in some notification that he had tested positive for COVID, which is why he had come in. Right. I would ask for a KPS, but I don't think there's anything else that the court needs to do today, considering he should have an active warrant in this case already. So.
Okay. Very good. So we'll just make sure that this, you want to just, for tracking this, put it on the next pre-trial, just.
Sure. Perfect.
We'll do it for, we'll continue this until 4/12.
Thank you, Judge. That's all I have this morning.
Even if he gets out, we can still run.
Okay. Have a good day.
Thank you. Is Ms. Herndon?
Your Honor, Ms. Herndon was here for was on the docket for Mr. DeLuca. A written plea and abstention has been filed.
Okay.
And the court did sign that order.
Okay.
So that case should be off the docket.
Thank you for letting me know that.
Was it put on your report? I'm thinking the order was that. I don't have to close that.
If we could check that, if not, we'll just need to put it on the next pre-trial. Okay. Dwayne Sheldon. Whose case is that?
It's mine, Judge. So.
It's mine.
Yes.
Yeah. Your Honor, I think this is a Ferretta hearing.
Right. And the counsel
Is he not
withdrew that.
incarcerated?
Actually, it's here on a motion hearing. I'm assuming it's a Ferretta hearing also.
Was it?
But I kind of surmised. Yeah, bring it. Thank you.
Yes, Your Honor. This is 22 CF 1662 and 22 CF 2422. Your Honor, from my recollection, we're here today for a Ferretta hearing for Mr. Shelton. Mr. Buck had been appointed to him, but he indicated to the court that he wanted to represent himself. And so the court needs to do the Ferretta inquiry or appoint him someone else off the registry list. If the court recalls the conversation that we had about Mr. Buck, I don't, I'm not sure that Mr. Buck is really gonna make a notice of appearance for him in this case.
So, Mr. Sheldon, what's the status of legal representation for you, from your understanding?
My understanding is I haven't, it's been 7 court dates, I believe, that I've had one lawyer represent me.
Mr. Buck?
No, I've never seen a Mr. Buck. I've
Okay.
looked him up online.
Has anybody represented you?
Mr. Keach previously represented Mr. Shelton, but
For
he has a
7 days.
conflict, and before that, I'd have to look back to see.
It was Martin Notes before that, then it was David Stevens before that, then it was Jacqueline Jarquette before that, then it was Jason McKinney before that, and there was someone else in between, I don't even know. I've never seen one of them except Mr. Notes, and he came up one time to see me.
And you know why that's happening? They have conflicts with all the other situations that you've been involved with. It's very unusual for this to happen. I just want to let you know why it's happening.
I understand some of it, but I mean, for the fact that Mr.
So let me
Buck-
just ask you, so we're here today
Fred.
on basically talk about your status with your legal representation. Are you intending to hire, what do you wanting to do?
I've lost almost everything being in jail for 7 months. I went from a signature bond to no bond, and I don't understand why that alone, but I had a job. I mean, I got a brother that's a contractor. I can get back to work if I can get a bond and get a lawyer, because obviously around here I'm not going to be able to get one. And that's the only reason I said go Ferretta, which I could read well, I could write well, I can get there and do motions, but I mean, I'm not by far a lawyer. It wasn't even attempt
Do you want to have an attorney appointed? If the court will allow it?
If the court will allow it, yes. But I mean, if I'm going to go 5, 6, 7 more months without a lawyer, then I might as well take a shot at it myself, because my case don't seem too hard.
I agree. You need to have an attorney. I think the problem is we are running out of names on the list, right?
Well, no, sir, it's just normally done by motion, and then Ms. Van Boxtel will send us an email, and then we go to the list from there. I'm going there now.
This was a little different because he basically requested a Ferretta, but.
What I asked for was if I can have motions wrote, because if I can have motions wrote, I don't see no way I'd be found guilty on these charges. I mean, I know I'm not supposed to be talking about my case, but that's what I asked, and then you asked if I wanted to go pro se, and I said yes, because you found.
Okay, so let me ask you a few questions. I'm going to swear you in. Would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, my first question to you is, do you want to have an attorney appointed? I know we've gone through a lot of history, but are you wanting to, you want to have an attorney appointed?
Yes, sir.
Okay.
The next attorney on your list, are you reading Mr. Buck today?
Yes.
The next attorney is Jason Cobb.
Okay. So we're gonna appoint you an attorney today. His name is Jason Cobb. We're gonna go ahead and continue yours to our next regular pretrial, which is 4/12. And Mr. Cobb will get notice of this. Hopefully, you all will make contact between that time, so you all can begin to get your legal representation, which you have a right to. Okay?
Thank you, sir.
Okay, thank you. Okay, we've got a few folks here who are here for the first time that do not have attorneys. If you're here, I'm going to make a statement, so I don't have to repeat myself, because there are 4 or 5 folks that are in this category. If you've had a new violation of probation that's charged, that's been that you've been charged with, and you do not have an attorney, Today's hearing is designed to make a plea. In other words, on a violation, it's an admission or a denial. Because you've not had a chance to consult with an attorney, you may have consulted privately, but I don't have any records of it here. I'm going to ask you whether you want to have an attorney if you qualify for one. You very well may qualify for one. And I'm going to enter a denial. So the reason for that is that it will allow you to speak with your attorney in order to try to see how to proceed with this violation of probation, because this is a kind of a serious step along the process. So I'm going to call your name. If you would just come forward, and then we'll just make inquiry regarding legal representation. So, Michael Bennett. Do we have Michael Bennett? Okay, we'll jump over. Paris Brown.
Your Honor, Mr. Brown is unrepresented. He actually reached out to our office this morning. I guess his car broke down and he was trying to let somebody know who he knew would be in the courtroom.
In addition to that, Your Honor, the court should know that this violation is based on a new law charge, which is on April the 11th, plea day. So, if we wanted to...
April 11th?
We aren't, Your Honor. It's more of a friend of the court. He reached out and I wanted to let the court know. I'd hate for him to get cases after he's reached out.
Oh, I'm sorry, Your Honor, you said Paris Brown, not Anthony Brown. I'm sorry, I had the wrong person. This is a violation based on not, basically not completing the DUI requirement, Your Honor. I apologize. It's not based on any law violation. I had the wrong Brown.
You heard the defense
Yeah.
turn to the court state that he called their office and he broke down. Did he say he was going to be late, or that he just wasn't coming?
He wasn't, you know, he doesn't know if he can make it. He has no attorney. He's just trying to get here is the best I would explain it.
Why don't we see whether he gets here, and we'll pass over this and deal with it later. Maybe he might get here, even if it's a little later, and we can deal with it. Adrian Dismute. Would the state announce this case?
Yes, Your Honor. This is 19 CF 1387. For the court's information, he also has a case on this afternoon's docket, which is the basis of his violation. And I do think he is not represented in that case either.
Okay. So, Mr. Dismute, in both of your cases, your violation of probation this morning and then your new law charge that you have an arraignment this afternoon, you do have a right to an attorney in both of these cases. Do you wish to have an attorney appointed?
Yes, sir.
Okay. So what I'm going to do in both of these cases, I'm going to appoint you the public defender.
That'd be Mr. Medina.
And that'd be Mr. Medina, who's standing right behind you. And then we're going to enter on your violation of probation. I'm going to enter a denial. And on your new law charge, I'm going to enter a not guilty.
Yes, sir.
And we'll come back on both of these cases. We'll run the cases together, and we'll come back on 4/10 for pre-trial at 9 o'clock. And in the meantime, get the contact information from Mr. Medina and make sure I'm being in contact with him so you can kind of figure out where you're going.
Yes, sir. Yes, sir. Thank you.
Questions?
No, sir.
Thank you. All right. Okay, and Lambert Gabbins? Would the state announce?
Your Honor, this is case 22 CF 107. Mr. Gabbins is before the court on an alleged violation of probation on a misdemeanor for failure to pay costs. May I inquire with probation, are you aware of costs have been paid at this time?
defendant owes $417.60.
The state would be willing to dismiss this case on the payment of costs, just however long you need, sir.
It's already been paid on.
Oh, okay.
Okay.
I'm just hearing something different from. Thanks. Madam Clerk, can I inquire, do you see if there are any costs outstanding?
They may have notated supervision costs.
And that's what I'm wondering.
Fines, they are paid.
Okay, so it sounds like probation, would it be accurate to say that supervision fees are what remain?
22 CF 107, I'm seeing a current balance of $371.54 and his drug testing fee.
Okay.
What's the drug testing fee? That's an additional charge?
Yes, sir, it's just $30 one-time fee.
So all to say, if Mr. Evans would like to continue this case for whatever period of time is necessary to work out what may be owed or is not, the state is willing to dismiss this matter. Sure.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients.
The court's going to waive the defendant's cost of supervision. We're going to continue this case until, why don't we do the next? Okay. We'll come back for April 11th in the morning, but you need to check with that waiver of supervision. We need to check with probation to see kind of where we're at with things. Hopefully, you can pay whatever you need to, and we can get it dismissed at that point.
Sir, the waiver for cost of supervision does not cover the drug testing fee?
That was the one thing that I mentioned to him, and I believe that that's correct.
Yes, sir.
So whatever is owed like that, he'll communicate with you so he can figure. He's not exactly sure. And some people pay this and that, and he's trying to get that situated. So if it's just $30, then, you know.
It looks like his trade fee, which is $2 a month, and his cost of supervision are at a zero balance. That just leaves the drug testing fee and the court costs listed here, sir.
And are there 4 o'clock? Where are the 4 o'clock? I know they were paid.
I showed that they were paid.
Okay. So it looks like it's $30. So he'll pay you, and then we'll get it. Will somebody contact him, let him know he doesn't come back?
Yes, Judge, I'll inquire with probation. We'll say near the beginning of April about the $30 fee. If it's paid, we'll dismiss the case well in advance of your next court date, sir.
Okay. Got it.
Thanks, sir.
Thank you.
I don't know how they're going to do that. It's a DOT, so would you file something?
I would file something, yes.
Okay. Thank you. Okay, are we ready to make? Frank, are you back up here? Who do you want? Was it if it was, sorry. Michael Bennett and Anthony Brown, sorry.
Online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
With the state announcement, please. This is Michael Bennett.
Yes, Your Honor, this is 20 CF 1937. Mr. Bennett is here this morning for a violation of probation.
So, Mr. Bennett, on this new violation charge, you do have a right to an attorney. You wish to have an attorney appointed?
Doesn't matter.
Yes? No? What do you mean it doesn't matter? Yes?
I mean,
She's looking at you. Are you looking for an offer?
Yes, sir.
Okay. Does the state have an offer to be made on this violation?
Yes, Your Honor, give me just a second. I do not have files on violations anymore, so this would be an offer sheet. State's offer is to revoke and terminate supervision, a guideline sentence.
Which is?
34.8 months in the Department of Correctional.
Okay. I would suggest with a DOC sentence being offered, that you go ahead and accept public defender and discuss it with, when you're dealing with time, you need to discuss it with legal counsel.
Yes, sir.
Okay, so the court is going to appoint the public defender, and we'll come back on 4/12 for pretrial.
Your Honor, may I ask a question?
You may.
On behalf of the Public Defender's Office, does Mr. Bennett have a new law charge? Is this purely technical or something of that nature?
It is a new law misdemeanor, I think.
A new law misdemeanor? Okay. I'm going to give him my card, Your Honor, and we'll be at the stand.
Okay.
As far as the next court date, Your Honor, you want to put it on your April 11th? It's not a new charge. You can ask April 12th.
Well, yeah, it's a violation. Yeah, we'll come back on the 11th. That's correct. Doing a denial today, correct.
Thank you, Your Honor.
Thank you. Mr. Brown, Anthony Brown. Would the state announce, please?
Your Honor, this is 22 CF 2333. Your Honor, Mr. Brown has a violation this morning for a new law charge, which is on which the plea date is April 11th for the new law charge.
The plea is April 11th?
Yes.
Okay. So, Mr. Brown, with these new violation charge, you do have a right to an attorney. You wish to have an attorney appointed?
Not at all.
No?
No.
Why don't you want an attorney? You gonna hire private counsel?
Because all y'all are in cahoots together.
I'm sorry?
You, the state, all y'all are in cahoots together under your rule book. I don't recognize that rule book. Number two, I never got arrested on this VOP. I don't even know what the VOP is for, besides what she just said. That's number three. And so, I mean, that's one of the reasons why. I don't even know I never got no paperwork saying about a VOP. I never got arrested on a VOP. I just been held without a bond on a VOP.
Well, I would suggest that you accept a public defender, because that's exactly what the public defender can do, can interface and argue on that and communicate with the state as it relates to that.
Your yeah, but the suggestion is that even suggested when my life got me in the situation I'm in today. So I don't want to go on anybody's suggestions.
So you want to just represent yourself?
That's what I said.
Well, I just want to make sure, because in the state of Florida, will pay for an attorney if you can't afford one. You understand that? And you're saying you don't want an attorney. Is that correct?
I said that.
Okay. And you understand that if the court doesn't appoint an attorney, you're going to basically be representing yourself. So you'll be wearing two hats. And
well, I wear a lot of hats anyway. I just posted a thing about.
Listen to what I'm saying to you. I need to ask you some questions to make sure you understand, because as a general rule, it's not suggested for you to operate without legal counsel, because I don't know. Have you been trained as a lawyer? Do you understand all the procedural rules and the substantive rules?
Curses and hexes that y'all pronounce. That's what I know about. I know that we're in a hot war dealing with the space and stuff like that. It's not a nuclear, the Cold War. I know that much. So, I mean, those are things I do know. I mean, we can talk about things like that. I mean, I'm not here for that. I'm here for one reason only.
Your Honor, can I approach the bench?
You may.
Thank you.
Mr. Medina?
From Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is...
So, Mr. Brown, do you wish to enter a denial here today of your violation of probation?
I don't even know what the violation of probation is. I never happened to.
The court's going to enter a denial. That'll make sure and protect your legal rights.
Okay.
The new law violation, the reason why you had a violation of probation is you picked up a new charge.
Okay.
And you're going to be appearing on that new charge on April 11th.
Okay.
So you'll have arraignment for that. So we'll figure out where this is. We'll actually track this one with the arraignment on 4/11. Okay, so we'll track those two cases together. Okay? So at this point, I'm not going to appoint an attorney, but I may ask you about it again in the future to make sure you continue to not want to have an attorney. Okay? The court's entering a denial. Thank you. Okay. Mr. Gates, you're up.
Yes, Your Honor.
We'll begin with Jeffrey Felton. Unless you want to do some out of...
I do have one out of custody, Your Honor, if I could take. Clear the courtroom a little bit before for a while.
Sure.
Rebecca Farakis, Your Honor. Ms. Farakis should be number 21 on the docket.
Correct.
Your Honor, Ms. Farakis will pleading to a lesser included offense in the information of felony theft. Madam Mayor, approach, Your Honor. Get the Constitution on all the probation is over. Your Honor, Ms. Farakis will be entering a no contest plea to the lesser included offense of petty theft. She was adjudicated guilty, placed on 11 months, 29 days of probation. We're going to support the waiver of supervision fee. I had the wrongful process section 270 in court costs, Your Honor, 150 public defender fee, $43.75 in restitution to the Family Dollar, no trespassing at any Family Dollar.
Very good. Ma'am, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in your written plea agreement. Is that your understanding what the terms of the plea agreement are?
Yes, sir.
Okay. And if you had a chance to go over, first of all, have you read the plea and sentencing agreement?
Yes, sir.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering into this plea, you're waiving some rights. The most important right is the right to go to a trial, right to contest this.
Yes, sir.
You understand, you believe it's in your best interest to do so?
Yes, sir.
You've had all your legal questions answered of Mr. Gates, by
Yes, sir.
Mr. Gates.
Yes.
Okay. Nobody threatened, of course, to get you to enter into this?
No, sir.
Okay. Based upon that, the court will accept your plea here today. State's an agreement, I assume.
Yes, Judge.
Right. The court will accept your plea. There'll be an adjudication of guilt. The court will sentence you to 11 months, 29 days of probation. There will be a waiver of cost of supervision. Then you have court costs and fees as contained, as well as the restitution to the Family Dollar. No trespass. Take that real serious, okay?
Yes, sir.
Don't trespass on Family Dollar. They'll won't respond well to that. Okay? Thank you.
Over here, man. And I'll turn the floor over, Your Honor, let the clear the courtroom out here.
Okay. Could I call a few?
You may.
Thank you, Your Honor. We've got some continuances and then please respond to plea.
Okay.
Your Honor, if I could call David Tyrone Adams. Mr. Adams is approaching, Your Honor, in 22 CF 2573. I'm asking to continue him to April 10 pre-trial. This is a new law case. We're waiting on a Phoenix House evaluation, and if we can get a positive evaluation, we're able to work this case out. The other possibility is a straight jail option or trial, and I've asked the state to, at his request, get a straight jail offer. I don't know if Ms. Sharpless has an opportunity to do that. Set aside for just have him come back April 10th.
I would have him come back April 10th.
Can we just continue him to April 10th?
We'll continue this case until April 10th, and this is 22 CF 2573.
Yes, Your Honor. Thank you.
Thank you.
Your Honor, next is with a plea agreement is Nathan C. Atkins. Mr. Nathan C. Atkins is approaching. You need to remove your hat. He's in 22 CF 2577, Your Honor. And he's going to be doing a plea and sentence agreement with the court's approval for supervision by Judicial Correction Services, JCS. So may I approach with the agreements on this conveners, Your Honor?
Thank you.
And I'll announce it with my copy if that's okay.
Great, thank you.
Your Honor, I've given him a copy because he will need to meet with JCS. Does bailiff have a JCS card? Thank you. Your Honor, under this agreement, Mr. Atkins is going to have a withhold of adjudication. Withhold adjudication to lesser included offense trespass or first degree misdemeanor trespass. The section is indicated on the paperwork, 810.082B on count 1 instead of the third degree felony burglary charge. And he will also have a withhold on count 2 as charged, which was a second degree misdemeanor criminal mischief. There will be 11 months, 29 days probation on count 1, which again is the lesser included offense trespass. There will be a concurrent 6-month probation on the count 2 criminal mischief charge. There will be supervision by JCS, and the bailiff has kindly provided him a copy of the JCS address and phone number. And Your Honor, he will be eligible for online reporting. After the initial intake, he would need to go report today before he leaves. He does live in Texas, so the parties would not object to him living in Texas. He would have to get a substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. He'd have to do random UAs, 270 court costs, 150 PD fees, 24 hours community service, no contact with Paula Kelly, no trespass at 114A Edge Avenue, Niceville, Florida. You would have to show proof he's a full-time student or maintain gainful employment or complete 2 applications per week. He represents to me that he is not going to school, he is working full-time at this time. Anti-theft class and a reserved jurisdiction for 90 days on restitution. There will be a withhold adjudication as I stated.
Statement agreement?
Yes, Your Honor, that is the state's agreement.
Mr. Atkins, would Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, heard your attorney state in detail the terms of your plea agreement. You can put your hand down.
Yes.
And I see that those same terms are contained in the written plea agreement that you've signed. Have you, first of all, have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered about the plea agreement?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving some valuable legal rights.
Yes, sir.
And that's the right to go to a trial and the right to contest this. This will be a final adjudication of your case. You understand that?
Yes, sir.
Okay. You believe it's in your best interest to do this here today?
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea agreement. There'll be a withhold of adjudication. There'll be a lesser included charge on count 1 of trespass and count 2 as charged. There'll be 11 months, 29 days probation as to count 1, and then 6 months as to count 2, but they'll be served at the same time, so it's basically a total of just less than a year. There'll be supervision through JCS, which allows you to go back to Texas, and they'll be eligible for some online, so there's some accommodation that's being made, but you're going to have to follow through. The key thing with this, you're going to have to follow through with this in detail, because you've got a lot of other things that are, you got to do substance abuse evaluation, recommended treatment, community service, proof of employment. There's a lot of things, and the most important thing is you got to stay in good contact with your probation officer so that you follow through, because if not, you'll get violated on that. There'll be somebody coming to try and pick you up. We'll be drugged back here to deal with these charges. Not good.
Yes, sir.
Okay? So take this serious. You can get this put behind you, but you got to take it serious. It's only a 1-year probation. You can do this, but you need to show up. You need to take the affirmative steps to make sure and follow up on this stuff. I'm just telling you that because I really don't want to see you again. You understand? No, I'm serious. You know, 50% of probation cases fail. That's disheartening to me. We put you on probation. Oh, I'm happy I'm on probation. I don't got jail time. Then half of them fail because people don't show up for their probation officer.
Right.
Okay? I'm just talking to you honestly, person to person. Okay? Very good. Any questions? Okay. Thank you very much.
Go to that address on the card today, okay? Right now. Thank you. Thank you, Your Honor. Your Honor, next on a motion to withdraw is Thomas Bello. I don't know if we have an interpreter though. We may need an interpreter. He has a family member. I don't know if that's an official interpreter. I apologize, Judge. I don't know why we don't have an interpreter here. He has did his family member come and interpret for him, Your Honor? Or
We don't know this.
We don't have an interpreter on campus.
I know that's what we believe.
We may have to reset it for, sorry, Judge.
I mean, what?
Or if the court
This is a
wants-
motion to relieve the public defender.
Yes. Your Honor, or if depending on how late we go this morning, if we want to leave him to see if we can use language line. I don't know if that's something we want to use language line for.
Certainly fine with me, Your Honor, whatever the court's, I apologize again, I don't know why we didn't coordinate with administrative services, maybe we tried to, I don't know.
What language did he speak?
Spanish or Portuguese? Spanish. Do you speak English too?
Okay. So I'm okay with using language line.
Your Honor, can we just set them aside till later in the morning?
Yeah.
And then we'll take care of it then? Because as stated, I don't want to delay things anymore if we don't have to.
If I could interrupt, the Spanish interpreter should be here for the afternoon today. While I wait, I can send a text to her to make sure that it's proceeded, she'll be here this afternoon. Their afternoon starts at 1:30. She usually gets here a little early.
Can you come back at 1:30?
1:30 esta tarde. Okay?
Let me just make sure. Don't have to wait.
Okay, come back at 1:30. He can just come back at 1:30, Mr. Bailiff.
I'll make sure that she's coming.
Okay.
Sure to come back.
Okay, siéntese, por favor.
Okay.
Your Honor, next is and Alonzo Borum, Mr. Borum is approaching. Mr. Borum is approaching, Your Honor, 22 CF 1169. I have discussed the case yesterday with the state, and I've asked the state to reconsider whether he can go into mental health court. We as an option, are finalizing our preparation for trial. We're resetting a former deputy sheriff, Molinarski, for a deposition. I expect that to take place fairly soon. Can we just continue him to April 10, Your Honor?
State?
Your Honor, that's fine with the state.
And does the state, well, just if you'll consider our question, with D. Adams, she felt he was going to be eligible, but she didn't see anything in his priors that was disqualifying, but the state has to agree, obviously. Ms. Sharpless wears both those hats, so we'll coordinate with her. If there's any way to do mental health court,
okay,
we'll try to do that.
Okay, we'll revisit that again on the 10th, so let me know.
Okay, thank you, Your Honor. Thank you, Ms. Bourne. Your Honor, next is Jimmy E. Case. Your Honor, we may need to set Mr. Case aside. Do you think we might be able to resolve him today? Pardon me? Yeah, I have to talk to him if you're okay with that. So let's just set him back, set him something. Just have a seat and we'll see if we can work Mr. Case out in the next hour or so, Your Honor. Thank you.
Okay.
Next then is Miss. Yes. Just have a seat. Miss De Benedetto, Carissa Angelina De Benedetto, Your Honor. She's approaching. Thank you. Your Honor, FDLE is outstanding in her case, and she's requested that we wait on FDLE to see what he wants to do in this case. I don't know when we're going to get it. It was it's December 12 incident, so we'll probably just need to keep her on April 10, Your Honor. Maybe we'll get it by then.
Okay.
Can we continue to April 10, Your Honor?
Very good. We'll continue to April 10th.
Thank you.
Thank you.
Thank you.
You skipped over Michael Bratton.
Oh, yes, Your Honor. My understanding is that Mr. Bratton, he's not at the jail. My understanding is that was an appointment from a Burt Moore case, and the PD was appointed while I understand Mr. Bratton may be in DOC. I've not had an opportunity. I was out last week to locate him and see what
We've got this just listed as a status.
Yes, Judge. I think if we could continue the status hearing, maybe to April 11 or something like that, I'd look into it. My vague understanding, and I just got the file this morning, is that it's an open, like, trafficking case, and that he was doing some time, and perhaps he was wanting a concurrent.
You want to just come on a regular pretrial rather than a miscellaneous? It doesn't matter either way.
It would, whatever the court prefers, and I will also note for the court that if it looks like he needs to be here, which he probably does, I'll prepare a proposed order to transport for the state and the court's consideration, because he probably has a right to be here.
Okay, so let's schedule this for 4/12. We'll continue to pretrial.
Thank you, Your Honor. And if we need an order, I'll propose it, Your Honor. The next one is, I don't know if Mary Mason is here. Is it Mary Mason? Miss Mason? Mary Nell Mason is approaching in 21 CF 2586. We had been seeking the state's consideration of a PTI or deferred prosecution agreement. In meeting with Ms. Mason, it became apparent to me that she makes almost $4,000 a month in monthly income. I'm sure she earned every penny as a disabled veteran, and she may receive Social Security too. I think there was a question of, on her application, whether people were dependents who really are not her legal dependents. So I don't think she's going to be eligible. We filed a motion to relieve the public defender. As a officer of the court, especially with a disabled vet, I didn't want to leave her hanging if we didn't have to, so I've asked the court, I reached out to the prosecutor's office and asked them to consider DPA or PTI for her. She did have a prior private lawyer and apparently spent all her liquid funds on that. So, but I did need to raise the motion to relieve the public defender, Your Honor.
Is there an offer on the table?
Your Honor, state's offer for this case is a 10-month pretrial intervention agreement with a couple other various terms, but substance abuse eval and treatment being the primary.
She's shaking her head that she doesn't want to take it, Your Honor.
I'll go to jury trial. Jury.
So, ma'am, are you you've heard your attorney state that he doesn't think you qualify for the public defender. Do you dispute the monthly income?
No, I
so do we? So let me just ask you this: has she filled out her form with the and she was approved, Mr. Medina?
She called people dependents that they aren't technically her legal dependents, and apparently she has some people that live with her, but they're not legal dependents.
As long as the clerk didn't raise an issue, I'm not going to go out of my way to raise it. If the clerk didn't raise it, the clerk didn't feel that it was an issue.
Well,
sir, if he doesn't want to represent me, then I'll agree with him to let him go. I've got my house up right now for a loan.
Well, the problem is you'll be operating without an attorney. You don't want to be operating as an attorney.
I do not. But I don't want to accept anything but trial by jury.
I'm sorry?
I don't want to accept anything but trial by jury.
Okay. Well, you can definitely get that. You have a right to it.
Thank you.
Okay.
Is the court going to deny our motion to relieve?
I'm denying the motion. Okay.
Your Honor, she's indicating a desire for a trial. So can we leave her on April 10th? And
no, sir. I want to have a continuation of time. So in case I want to put a motion before
Ma'am,
the
got an
courts.
attorney. Let him talk.
Yes, sir.
So we're coming back. What he's suggesting is that our normal pretrial is 410.
Yes, sir.
That's the first part of our next cycle.
Yes, sir.
And at that time, every one of the cases, they call it pretrial, but essentially it's a review. We review every single case that's before the court. Okay. So talk to your attorney between then. And, if you want to go to trial or if you feel more time than you need for discovery or preparation, we'll deal with it then. Okay, so come back at 4:10 at 9 a.m.
I think she's indicating, reading between the lines, Your Honor, that she may wish to get another private lawyer. If she wishes to do that, hopefully that'll get notice of appearance done by April 10, and then the court can consider further matters. Okay.
Ma'am, you always have a right to get a private attorney and substitute.
Thank you, sir.
Thank you.
Thank you. Your Honor, my only other warning out of custody, just for the record, Ron Rico Devon Jackson, he's not here, but my office called him. I talked to the state yesterday. We're very close to working out his case, hopefully. Mr. Jackson's case was 21 CF 2451. Ms. Sharpless and I discussed that it would not be necessary for him to come today because we can hopefully work out his case on April 10. I hope that's okay, Your Honor. If we could just continue into April 10. There were restitution and other issues that the state was hopefully going to be working through by April 10.
That's correct, Judge, and if we can't work it out, I understand how old this case is. It even predates my appearing in this division, so we will work towards a trial if we cannot work this case out.
Very good. So we'll continue this until our pretrial on 410, and we'll move toward trial if we can't get a result.
Thank you, Your Honor.
Okay. Let's take our morning break. It's about 10:45. Let's take about a 10-minute break, and we'll come back and do the rest of our documents.
All rise. Where's the recess?
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Pretch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
How do you want to handle it? I'll let you guys decide who gets.
Hi, I'm Amanda Gaskin with Pretch Realty.
We can go and order brand new children. I do see some more people in here, and that's what we'll take them first.
I have some that are out of custody, Your Honor, but.
I'm sorry?
Go whenever you like. I have a few that are out of custody, but.
Let's go ahead and call them up.
Some of them need to come back in the
Sure,
courtroom, but
sure.
the ones that are here, Mr. Lorenzo Gordon. Ryan Martin.
Is that Gordon
with G, Your Honor.
Okay. Hold on, sir. Let me just find it.
Certainly, Your Honor.
It's all right. Okay, got it. Go ahead.
This is 19 CF 3306. We'll be entering a negotiated plea on the GOP. There won't be a score sheet on here on misdemeanor counts. The agreement contemplates for us the court to revoke and terminate probation 90 days counting.
Okay, come on up here and listen up.
Good morning.
He's announcing the plea agreement that you're entering into. Go ahead and start over.
Yes, Your Honor. Agreement of the parties contemplates will ask the court to revoke and terminate the probation, 90 days county jail, credit for all time served, $100 VOP fee, $150 cost of defense, financials reduced to a lien 1 year after release. And I'm just going to add on here that that will be on each case concurrent, Your Honor, or count rather. May I approach? I believe I
was just saying good morning, Mr. Ketchel.
Good morning.
Didn't mean to interrupt.
Thank you. So, Mr. Gordon, would you raise your right hand? Yes, ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement. Have you read this plea agreement?
Yes, sir.
And have you gone over it with your attorney, made sure you had all your legal questions answered? You understand that by entering this plea agreement here today, that this is a final resolution of your case here. Do you understand that?
I understand, Mr. Ketchel.
And you believe that's in your best interest to do that here today?
Yes, sir.
You've had all your legal questions answered by your attorney?
Yes, sir.
Is the state in agreement with this?
Yes, Judge.
Based upon that testimony, the court will accept your plea agreement and will revoke and terminate the probation, so you'll be finished with the probation.
Yes, sir.
You will be sentenced to 90 days in the county jail. On each count, they'll be served concurrent at the same time. So you have basically a total of 90 days with credit for time served. Then you've got fees and costs that you've got to pay within the year after you get out, or it goes to collections.
I understand, Mr.
Okay?
Ketchel. Yes, sir.
Okay. Thank you very much.
Now, will I be arrested today?
Yes, sir.
Okay.
Alfiero?
Yep. Thank you, Mr. Ketchel.
Ryan LaRose, Miss Alfiero, Your Honor.
Would you announce again? I'm going to find it.
Yes, Your Honor. This is Miss Joy A. Alfiero, 19 CF 130. Miss Alfiero with an A.
Very good. Thank you.
And this is going to be an admission on the VOP with a negotiated plea, Your Honor. We're going to be asking the court to revoke and terminate the probation and to reduce all financials to a lien, $100 VOP, $150 cost of defense.
State agreement.
Yes, that is the state's agreement. I'm sorry, Judge, I was just making sure that I, had the score sheet on record.
Thank you.
I'm trying to spell her name correctly.
Okay. How do you pronounce your name, ma'am? Alfiero?
Alfiero.
Alfiero? Okay. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of the plea agreement. I see it's also contained in your written plea agreement. Have you gone over this agreement with your attorney, make sure you understand all the legal ins and outs of this?
I believe so.
And you understand that by entering in this, you'll be essentially revoking and terminating the probation, and the fees and costs will go to collections. That's primarily what this is doing. Do you understand that?
I do, I understand.
And there'll be an admission for the VOP as a part of it. Do you have any further legal questions or any other questions regarding this?
I don't think I do. I just, my memory was just, I was so close to the end of my probation, so this makes sense.
Okay, very good. The court will accept the plea and revoke and terminate, and costs and fees go to collections. Thank you.
And Your Honor, I do
Yes.
need to print out the score sheet for the court, but her total sentence points are 23.7, so she
Very
does
good.
not presumptively score for prison. I'm going to show Mr. Morrow this score sheet, and then I'll print it out and give it to the court at a later time. If that's okay with Mr.
Thank you.
That's no problem. No
Yes,
objection.
ma'am.
Thank you.
Thank you, ma'am.
Thank you. You want me to just continue to call
Sure.
some adequacy folks,
Yes.
Your Honor? Mr. Sunwood? Mr. Wood, Your Honor. This is the first time up for Mr. Wood. I'm going to receive the state's offer. I'd like a little more time with Mr. Wood. I'm asking the court to consider continuing this to 4/11 so I can follow up. The state has no objection.
That's correct, Your Honor, no objection.
Very good. The court will continue this to 4/11.
Thank you, Your Honor.
9 a.m.
Ms. Holly Snowden.
Would you repeat that name again?
Certainly, Your Honor. This is Miss Holly Snowden.
Snowden. Very good.
19 CF 1894. Ryan Morrow for Miss Snowden. Your Honor, I'm going to make the same request here to go to 4/11. I'm in the receipt of the state's offer, but Ms. Snowden has some information she'd like for me to review, so I'm going to ask for 4/11.
Very good. So we'll continue this to 4/11. In the meantime, you can talk with your attorney and see where kind of things are at.
Thank you, Your Honor.
Thank you.
Mr. Jutros, Derek Jutros. That's
How do you spell that?
Your Honor. J-U.
J-U. Got it. Thank you.
Ryan Morrow for Mr. Jutros, 22 CF 500. The state has offered Keaton as a resolution in this matter, but I need to have Mr. Jutros evaluated. I'm asking, 4/11 may be fine, but I don't know if the court has a late April date or an early May date, depending on how long it takes me to turn that around.
We can either do it April 18th or May 9th.
I'll be out on the 18th. Would the court allow me to go to May 9th?
Sure. We'll continue this to May 9th at 9 a.m.
Thank you, Your Honor. Mr. Frazier. Ryan Morrow for Mr. Frazier, Your Honor, with an F, 21 CF 1956. Mr. Frazier has asked me to set this matter for an evidentiary hearing.
Very good. How long do you anticipate the evidentiary hearing to take?
Very brief, Your Honor. I will mostly hear on an allegation of whether or not treatment was complete and complied with. So it'd be long enough for the state to put their foundation on and maybe take a little bit of testimony from Mr. Frazier.
I guess 15 to 20
something
minutes.
we're going to a hearing on? That's the only issue, is whether or not he completed? Y'all are in disagreement on that? I mean,
I think the issue from Mr. Frazier's perspective is that the state offer is 11/29, so he's decided to assert his right to contested hearing based on that.
Yes, right to contested hearing, 100%, absolutely. Okay, well, I mean, you stated what the disagreements were, and I was just surprised that we would be going to a trial on that. But
yes, Your
he
Honor.
has a right to it, and I'm good with it.
I understand, Your Honor.
Okay,
Appreciate
so what do you think, clerk, just for an afternoon, May 9th maybe?
That would be fine with the defense.
You have two cases.
May 9th.
Thank you, Your Honor.
And that'll be at 2:30.
Your Honor, I believe those are all my out of custody folks that are present.
Okay.
I have one more that I have not seen yet.
Okay, so we'll wait and see if he or she shows up. So, Mr. Gates, you want to do your in custody or however we
Court
want?
security, I think, is in call the docket, Your Honor, and I'm good with that.
I'm going to call the RPS on the transfer.
Perfect.
So I'm going to start out, knock the first two females out, and then we'll go back to the top of that male. So first should be Linda Folt. Hey, Frank, down, give me the two females first. And then Linda Folt first, followed by Kaylin Mitchell. Full.
Ryan Morrow from Ms. Full, Your Honor. 3 matters before the court. These are 22 CF 2099, 21 CF 3067, and 22 CF 411 Alpha. We're asking the court to pass this matter to 411. Ms. Full has some information she'd like me to follow up on. I think it may change the state's position. I don't believe they have an objection.
It's correct, Your Honor, no objection.
We'll continue to what?
411, is that your next
Where are
date?
we, how many cases do we have on 411 now? In the morning? Okay, so we'll still do it then. We'll continue to 411.
And we're anticipating negotiated resolution in this matter, Your Honor. I'm not going to bog you down. Thank you.
Okay, good.
For today, I have this as a VOP. Has a plea been put in yet?
We'll enter a denial for the record if necessary.
Please. Thank you, Madam Clerk.
Next is Kaylin Mitchell. Approaching.
Ryan Morrow, Commissioner, Your Honor. She has 15 matters before the court on the court's docket. The state has made their offer. It's something Ms. Mitchell is considering. Again, I'm asking for 411 to figure out if we can, there's a negotiation here. We are anticipating negotiated resolution in this case as well. Cases.
Have there been pleas entered in all of these cases?
Your Honor, this may be her first time before this court, so we'll enter a denial if the court doesn't have that on file already.
Court will enter denials and we'll continue the matter to 4, 11, and 9 a.m.
Thank you.
Next should be Felton.
Yes, sir. Should be Jeffrey Felton. I have him as number 20 on the docket.
Okay, thank you.
Mayor, Mr. Felton is before the court on bond hearing.
Hold on a second.
Yes, sir.
Counsel, you may proceed.
Yes, Your Honor. I was just discussing with Mr. Felton on whether he wanted to say anything to the court. I don't think he is wanting to do that, Your Honor. Most of what he wanted to address, and I covered in my bond motion. Court, I think that he would be simply argument, Your Honor.
I'm sorry?
I think it's just going to be argument at this time.
Okay. You may make your argument.
All right. Your Honor, Mr. Felton's before the court with this charge of written threats to kill or do bodily harm. That's statute 836.10. I did a little bit of research on it earlier. Most of what I've seen, really, I would consider from the defense position to be overbroad and vague. Obviously, the DCA didn't disagree with me on that position. Simply, the allegation here is that Mr. Felton wrote a threat on Facebook. There's no subjective to it. It's all basically, did he write it? Okay, that's enough. There's no way to look at sent or anything like that. Had Mr. Felton followed up with, I'm joking, I'm kidding, still doesn't matter, because the way the statute's written, the way the case law is, that's all it takes is writing a threat. I did take a look at, because I kind of compare this to assault charge, in of that there's a threat that's made. The difference between assault or even aggravated assault with a deadly weapon all requires some sort of imminency, ability to carry out that threat. Here, there is nothing. He's simply a threat in the nebulous social media world.
Is that an element of the threat charge?
Imminency is not, and I'm trying to kind of compare it to what I do know with assault, which does carry imminency. This doesn't. It simply is he made a threat, somebody saw the threat, and I think there was a third element that I'm not quite getting, but essentially that's it. Now, I will say in this case, when reviewing the jury instruction as well as the case law, this threat was, and if I can find it, it along the lines of, hey, can somebody go down to this location and kill every man, woman, and child? I would say that I think that's a bit different than what the statute requires, because he doesn't say, I'm going to, he doesn't throw a weapon up on the post. He simply says someone should go down there and do that. And then follows it up a little bit later with, I decided this year to be a psychotic homicidal maniac. Reviewing the jury instruction, I didn't see anything in there where it would require what I'm going to say is procurement. Procurement, I think, is the second element, but that is procurement for someone to send the message. That's not an allegation here. He just simply posted a message saying, hey, why don't somebody go down there and do that? I will say, Your Honor, had he shown up to the American Legion with a weapon and made the same threat, that's a third-degree felony, punishable with 5 years. But because he made this statement on social media without any ability to carry it out, it's a second-degree felony, punishable by 15 years in prison. With all that said, Your Honor, the court's aware that the purposes of honor want to assure the appearance of the defendant at court and community safety. So I took a look at Mr. Felton's criminal history. He's got essentially 2 charges on the score sheet, worthless check and failure to have insurance. The bond motion does include 1 prior FDA, that was back in 2015. He wrote a letter to the judge, the court recalled the cases. Ultimately, when he entered a plea, that did incorporate the FTA. He was given basically $50 fine for that. If we're concerned with his appearance in court, pretrial services also part of the bond. We're not asking the court to defeat that. We're asking the court to put it on. We're simply saying that the court can assure his appearance by setting a lower bond in this case and requiring mental health pretrial services. As far as community safety is concerned, Your Honor, I don't see anything in here that would be a red flag for prior criminal history or violent charges or anything like that. And I think if the state is concerned with that, mental health pretrial services would assist in him getting into treatment, taking the medication as part of what they do. That could alleviate some of that concern. My opinion on the bond, it's $250,000. You know, that seems a bit high. I think the bond is kind of a way to punish Mr. Felton because he's essentially stuck in jail until the resolution of the case. Mr. Felton is homeless, but he does have significant ties to the community, as I pointed out in the bond hearing, including being here, living here all his life, essentially 49 years. He does reside, live in his vehicle, but it's kept on the property where he's worked. He's worked there for at least 4 years, and I think he was about to get promotion got promoted at the company. I think the court could and should lower the bond. We're asking for $2,500 cash, professional or a signature bond, and that if the court was inclined to do that, keeping mental health pretrial services as a condition as well.
So, Your Honor, the first thing I'll do is go over the allegations in the case. In regard to this specific case, there are 3 statements that are at issue. So the first so these are all posts on Facebook. Hey, would someone go into post 23, I think on Hollywood Boulevard, FWB, and kill everyone? Man, woman, and child, thank you. You have my gratefully appreciation. That was followed up with a post that said, County Sheriff Department will kill me. Followed up with, I've decided this year for my New Year's resolution, I'm going to become a ... psychotic homicidal maniac. I'd also like to point out to the court that discovery in this case indicates that the defendant has previously made statements in 2019 regarding, quote, shooting as many man, woman, and child in Okaloosa County as possible. When law enforcement confronted Mr. Felton in this case in regard to this specific matter, Mr. Felton did not indicate that he was joking. He said that he posted it because people were, quote unquote, gang stalking him, and that he wrote the post so that other people could carry out the threat. Of course, Mr. Felton's bond is set at $250,000. So in regard to the reference by Mr. Gates in relation to this statute being unconstitutionally vague, this statute has been attacked previously on that basis. That was in the 50 CA Sadie versus State 845 Southern 2nd 1022. The statute, of course, stands as written. Your Honor, what I'm asking the court to consider in this matter is 903.046 sub 2 sub e. That indicates that in setting bond, the court may consider the nature and probability of danger which the defendant's release poses to the community. Mr. Gates is accurate. Mr. Felton has a limited criminal history. However, the bond is currently set as appropriate, considering the very explicit threats made in regard to a very specific location, which is unequivocally threatening in nature. We're asking the court take that into consideration. I believe the bond is currently set.
Gates, I'll give you the time.
Yes, Your Honor. And I would simply point out, I said that I think the statute is vague and overbroad. I also said the DCA disagrees with me. I did also point out to the court that one of the issues I had was that this is a very strict type of charge that doesn't allow for any other subjective argument, like, as I said, a joke or something along those lines. And again, even then I said that's not the case here. Mr. Felton never said that. What we do have, as I said, is when I look at the jury instructions for this case, it says defendant made a threat. Again, I would argue that the threat really was, hey, someone else go down there. Again, I don't see where it says anything about procuring other than the statement in the second element of the jury instruction, which says to procure someone to send the message. That's not alleged here. He simply posted this on Facebook. I would also say that it's probably going to be more than just a statement. It likely was along the lines of some sort of communication or conversation that Mr. Felton's having. As far as limited criminal history, I would again point out he has very limited criminal history. And if he did something similar in 2019, here we are in 2023, and Mr. Felton has still no criminal history, even with a threat back in 2019. Again, Your Honor, I think the $250,000 bond on this case is a little high, considering I've seen charges of aggravated battery or aggravated assault at significantly lower amounts than what Mr. Felton has. I'm asking the court to just lower the monetary portion of the bond, keep everything else the same, and let us work this case in the system.
The context of safety to the community is something that differs over time, I believe. And our day and time calls for us to be very sensitive to threats such as this, which are protected under the law. This bail is high, and based upon the defendant's lack of criminal history, but acknowledging the severity of the allegations, the court will reduce his bail to $150,000, which is still a high bond.
Sure.
And all the other requirements of the bond remain the same.
Additional.
Thank you.
Next should be Vicente Garcia with a G, Garcia.
Your Honor, this is Mr. Vicente Garcia. He is number 22 on the docket. I actually have two cases. I have 19 CF 699 and 22 CF 1718, but I think I only saw one case on the docket.
The only one I have is 2217. Garcia.
Garcia.
Yes, Your Honor. They're all should.
19,699 and 22,1718.
I just have one on my docket.
And that's all I had on the one docket I got yesterday.
Okay. Which case do you have, sir?
Both.
So let's go ahead and handle both of them. So
Yeah, sure.
is it 22 CF 699?
It's 19 CF 699.
19 CF 699 and 22 CF 1718. We'll
Yes,
handle
sir.
both of those.
Yes, Your Honor. The state and I are working out the terms on Mr. Garcia's case. If we could continue his case without subpoenas, my expectation is that we should have an answer by the time we come to court on a potential resolution.
Okay, so we'll continue it to 411?
Yes, Your Honor, that'll be plenty of time.
Okay. And we'll have both of those cases run together now.
Yes, Your Honor.
So which case is missing in the one which you already
The one that I do not have on my docket is 19 CF 699.
Okay, let me go to that case, and maybe because of the attorney situation.
Sure.
So I just wanted to print.
That's good. Take your time.
Are we good? Okay, thank you. Next will be Dane Solomon with an S, Solomon.
Yes, Your Honor. Ms. Solomon is going to be the last of my morning docket. Your Honor, we have a plea agreement to be filed to cover Mr. Solomon's case. Your Honor, may I approach with the plea agreement, Your Honor?
You may.
This is going to be as a modification. We won't be filing a score sheet in that case, Your Honor.
Thank you.
The state did tell me though that it's roughly 72 points, I think, on the score sheet. If I can hand a copy of probation, Your Honor.
So this is a downward departure?
It's a modification, Your Honor, so we don't need the downward departure in this case.
Okay.
Mr. Solomon is going to be admitting the violations before the court. He was previously adjudicated guilty. We're going to modify and reinstate his supervision. He'll be placed on 36 months of probation starting today. The first 12 months of the supervision will be community control, concurrent between both counts. That'll be followed by the balance of supervision, or 24 months of probation, which will be on concurrent. $100 cost of prosecution, $150 offender fee, required to complete any of the original conditions. The original plea agreement in this case required veterans court, which is ultimately modified to mental health court. He's completed that program successfully, so I want to make sure that that provision is taken out so that we're not looking at a violation because he isn't in the program. The psychological eval within 180 days of his release, record and treatment within 240 days, taking medication as prescribed. There is an injunction which was the basis of the violation, Your Honor. It's 22 DR 3738 that we need to abide by. It's my understanding that the victim in that case has already asked the court to modify the injunction to allow for contact. So I simply said just abide whatever that condition is. And this probation concurrent to any other cases he has, including the misdemeanor cases listed.
State?
That's the state's agreement.
Mr. Solomon, would you raise your right hand so you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney, you can put your hand up. You heard your attorney state the terms of your plea agreement that's also contained in the written plea agreement that I see you've signed. Is that your understanding of what the plea agreement is?
Yes, Your
Have you
Honor.
had a chance to review this plea and sentencing agreement closely and go over it in detail with your attorney?
Yes, Your Honor.
And you understand that by entering into this plea agreement, you're waiving some valuable legal rights, right? Go to a trial. This will be a final resolution of your case. Do you understand that?
I understand, Your Honor.
Okay. And you've had all your legal questions answered by your attorneys?
I did, Your Honor.
Satisfied with your legal representation?
Very satisfied, Your Honor.
Okay. Very good. With that, I'll end my colloquy now with that statement. The court will accept your plea agreement. The previously were adjudicated guilty. The court will modify and reinstate probation. The defendant will be placed on 36 months of probation as to count 1, beginning today. And the first 12 months will be on community control, followed by 24 months of probation. This will run concurrent with both counts. You got fees and costs that have to be paid within the terms of the probation, and then complete original conditions except for the completion of the mental health court program, which has previously been accomplished. So the psychological eval is a part of this, follow any recommended treatment, and also to comply with the injunction in 22 DR 3738. It's not the injunction is not my case, so I don't have any control over whether there's any modification. So make sure you handle that case separately and follow those rules as well as these, okay?
Absolutely, Your Honor.
Okay, very good. Anything else?
There you are.
Okay, thank you very much.
Thank you, Your Honor.
Next is Cedric Beecham with a B.
Your Honor, Steve Medina with Cedric T. Beecham. He's before the court on a continuation of his bond hearing. His cases are 20 CF 856, 20 CF 1938, 22 CF 2923. When he initially came before the court, there was a question about violent felony offender of special concern status that the state raised. I think that he wants to address that issue in testimony. I've asked him not to talk about the facts of his case. I'm not able to make any representations as to him not technically meeting the VFO special concern statutory language based on a case that I discussed with him and with the state. It's Williamson versus State, 180 South 3rd, 1224. It's the first DCA 2015 case, and that basically, as I understand it, the alleged qualifying offenses on his prior record predated 2007, but the Williamson case basically said in that case that even though a predating charge that was a qualifying offense was before 2007, it did not, it nevertheless met the term for a qualifying offense. So would the court permit him to address the court with anything he wanted to add? If he could be put under oath, just in case he has any information on this issue or anything else.
Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Medina, you wish to inquire of your client?
Yes, Mr. Beecham, without talking about the facts of the case, what is it that you wanted to tell the court? Because when you came back the second time, I cut you off because we really weren't set for a bond hearing, as you know. So you didn't get to say your piece, but what do you want to tell the court without talking about your case?
Well, yeah, it's not on the case, but I've been digging in this BFO of special concern, and as the state said a little bit of, no flight risk with the residents and the children and the family status. And what I was seeing in it was the past and the present. What we're looking at, what I guess they're saying is a qualifying offense, is something I caught as a juvenile and almost 30 years ago. And this BFO of special concern wasn't even in effect right then. So they're saying everything is saying I'm good, but the part I have an issue with is the special concern, because that's what we do is for the community and services and stuff. And I've proven in none of any charges past in or recent or anything has anything to do with violence or anything. So that's what we were doing, and I had recently went through something like this prior a few years back, and they issued a bond when I came back, but I had to go on some monitors and do my pretrial, and I completed all that with flying colors. Because what the issue really is, Your Honor, not just my family, but I have people that work for me, and I mean, the restitution and things that have come up in cases is going to weigh out greater, and I'm probably going to be going to court, even because I know the state and my lawyer are going to do their due diligence in proving this case to get a resolve. And I know your job is to make sure everybody's doing what they have to according to the law. But if I don't go out there right now, we're like getting loans and we're pawn and stuff, whatever we have to do, because my wife cannot sign any papers. She can't, the check, she has to use my phone to actually deposit to pay people. So what I was trying to do was get this bond while I'm still waiting, because like the state and my lawyer said, it's not really doing anything with me sitting in jail. But if I'm out of jail, at least I can get that and make closure. On contracts we can't get, we just got a hospital contract. On contracts I can't do, I can bow out of them and either do a refund or whatever I have to do to get closure on that. And the ones until I get closure on my case, I can get closure on. So that's what I wanted to come to the court and see if I can get it, because I'm not sure, you know, I'm not legal savvy, but I know it says a lot about the past and the present, and I know it's different little parts and pieces that control what the court says. And I know the court doesn't owe me, the state doesn't owe me, my lawyer doesn't owe me. He can only do what he can do. But I wanted to come and ask for a bond. However I can get that bond, meet those conditions, and then handle what I need to handle.
Thank you.
Yes, sir.
The state respond?
Yes, Your Honor, the state would respond. Your Honor, I can't comment on any bond that he might have gotten on these on any previous violations in these cases, Your Honor.
And it doesn't matter to this court what bond he
doesn't.
got on anything else. It matters what the application is in this bond.
He is a violent felony offender of special concern, Your Honor. There is a 1995 home invasion robbery with a deadly weapon and an armed burglary with a deadly weapon, Your Honor. Those are the qualifying offenses for violent felony offender of special concern. He's simply not entitled to a bond. And Your Honor, and aside and apart from that, he has a felony DUI in this new 22 CF 2923 case. He has a felony DUI in 20 CF 856, which he's on probation for. He has a felony DUI in 20 CF 1938, which he's on probation for. And Your Honor, he has 3 DUIs prior to that. So, Your Honor, even if he wasn't a violent felony offender, I would still argue that his drug and alcohol problems do pose a danger to this community. He's not entitled to a bond because of the violent felony offender status, and his actions continue to put this community in danger, and so I believe he should be in jail without a bond, Your Honor.
And would you comment on the timing of the prior offenses, the qualifying offenses?
that,
I think he's arguing that they were, when he was a juvenile. That's actually the case that Mr. Medina was referencing.
I would have to do the math, Your Honor. All I can tell the court is that they are CF cases. They are not CJ cases. So they were not he was not treated as a juvenile, which I think is the important issue to note. If he were treated as a juvenile, there would be a time period of whether this could be used against him.
And also the timing of it before the law was put into effect, the qualifying offenses, which is the case Mr. Medina, I think, cited.
Your Honor, I agree with Mr. Medina about that case. I think it's controlling.
So, one of the principles that a lot of people don't understand, often people will make an offhanded comment, well, you're the judge, you can do what you want to do. And that's really not true. I can do what I want to do within very narrow requirements. That, just like you, I'm required to follow the law.
That's right, sir.
And the law is as cited by the first DCA case that was cited. You know, the timing of when the qualifying offenses, even if they were prior to when the law was enacted, don't disqualify the qualifying offenses. And so clearly the court is not required to do this. I will tell you that it's obvious that you're a bright guy.
Thank you, sir.
And you're a capable guy. You got your own business knowledge. It's also clear that you're continuing to pick up charges of DUI that are dangerous to the community. There's been a prior ruling. The court's not going to change the ruling. You're going to have to deal with these cases and get them resolved. Hopefully, figure out some of the underlying issues and see if those can be corrected.
I agree with you, Your Honor. You know, as they say, no love lost on that. And I understand that there's some things, and like I said, I'm not as savvy as some with the law, but I know it's got to be some sanctions and stipulations, because like they said, well, I really don't agree with the threat to the community, because that's what the state said wasn't a problem, or a flight risk.
Well,
but
here's the issue, and I'm not going to enter into a discussion with it.
Yes, sir.
The problem with the community are the charges and the concern for the community are the DUIs. That's one of the leading causes of death in the United States is traffic deaths based on DUIs.
All right.
Anyway, thank you.
Just for the court's awareness, obviously, those are just charges at this point, and we've set depositions of employees to pursue on the DUI charge. Thank you.
And when do we have the next hearing?
Your Honor, I think he's probably already on April 12th pretrial, but that we ask to continue all three cases to that date. We're going to try to see if we can resolve his cases. If we can't resolve his cases, Ms. Sharpless has indicated she's probably going to set him for VOP evidentiary hearing prior to a jury trial.
Very good.
So April 12th, Your Honor.
Next will be a Thomas Burton with a B. Burton.
Oh,
you get Burton. Straight to Burton.
Your Honor, Steve Medina with Thomas Burton Jr. in 22 CF 1224 and 22 CF 1647. We were back before the court, in essence, for status to see if his best offer from the state is a 3-year DOC, and that would be a minimum mandatory to the trafficking charge in 22 CF 1647. He had offered 12.1 months DOC. Mr. Burton and the state attorney's office haven't been able to come to an agreement. So Mr. Burton has indicated that he wishes to exercise his right to a jury trial. I think that the case that would require trial is the second case, the 22 CF 1647, which does have the trafficking charge. I've given Mr. Burton my recommendation, but he's indicated he wants to proceed to trial rather than take the 3-year min-man, which was my recommendation. I'm going to do everything possible to represent him going forward. We have set a deposition of the ride-along person we were able to find through talking to the Sheriff's Department, and that deposition should be taking place prior to the next pretrial, April 12th. So we're anticipating a trial hopefully this next cycle, April 12th, and that's certainly Mr. Burton's wish is to get to trial as soon as possible.
I'm in total agreement. We need he has the right to go to a jury trial, and the courts has every intention to fulfill that right and to go to a trial on this case. Come back, continue it until 4/12.
Thank you, Your Honor. April 12th.
This will be Christopher Collis with a C. Collis.
Your Honor, Christopher D. Collis is before the court. We're here on a bond motion, Your Honor, in 22 CF 3027, 22 CF 1271, and 22 CF 1273. I filed a bond motion, and I would like to address those issues and basically some related issues. First off, as to the motion for bonds and bond reduction, he's respectfully requesting a signature bond. He has a $4,500 cash and professional in the new charge case, which is 22 CF 3027. He doesn't have a bond in the VOP cases. He's asking for a signature bond across the board. There had been a previous technical violation in the probation, but that had already been resolved. So basically what this comes down to is the new law case. And as to the new law case, Your Honor, we're not here to have a trial, but it is on two levels abundant that there are major issues. First off, there's the question of the production of Walmart video. Basically, almost all of the Walmart video has not been produced. We're not able to see in the Walmart video a close-up of who the alleged perpetrator is. So there's deposition set as to, there were 2 loss prevention officers at Walmart. One of the loss prevention officers sadly has picked up charges of his own, so he's become a defendant. And as to the allegations themselves, there has not been an identification of a prior suspect. Basically, there was apparently somebody who looked like Mr. Collis, who was the initial suspect who was stopped. He has not been identified to us. We have not received video of this encounter. And moreover, there were many things that just simply didn't match up. The contents of his backpack that he had showed that they were from Goodwill, nothing from Walmart. The backpack apparently didn't match. The bicycle that he was on didn't match. In addition, the alleged identification of him apparently came after a mugshot of Mr. Collis had been shown to the loss prevention officer, as well as the fact that prior to showing the, I would argue, tainting mugshot, after that, then they did a drive-by where basically it was Mr. Collis handcuffed. So that was not a very valuable identification. But there are many issues here. The bottom line is that he is a hard-working man. He has a good job in concrete. He lives with his wife, who's in the courtroom, and has been very supportive of him. He's asking to please go live with his wife, go back to his concrete job. He will abide by any restrictions that the court may wish to employ, but we really do need to preserve his jury trial rights in this case, Your Honor.
Your Honor, sorry, I was trying to speak up. Your Honor.
What are the specific bonds that he has in the different cases that you're seeking? I just want to make sure I'm clear about what
It's no bond on the VOPs, Your Honor, and it's a total of $4,500 on
Which of the cases? I've got 3 cases of his.
Yes,
Which
Judge.
one, are all of them VOPs?
No, Your Honor. The new law case is 22 CF 3027. That is a felony petty theft case.
Gotcha.
And there were allegedly some children's clothes that he allegedly took. But the things that were in the backpack had nothing to do with that. They were Goodwill items like socks. So there were lots of things that didn't match up. There was also a misdemeanor resisting retail purchase. Again, it really relates to...
So the new law charge is 3027 and the other 2 are...
That's
VOP.
That's correct, Your Honor. There was $3,500 cash professional on the felony petty theft and $1,000 cash professional on the resisting misdemeanor.
Your Honor, just to make this maybe a little shorter, the state would agree to let him out on a high signature bond. I usually request a $10,000 signature bond on the violation. If the court approves it, he does have quite a theft history, and he is alleged to have returned to Walmart when he was not supposed to. However, the only crime of violence that he has on his score sheet is 1 domestic violence battery, Your Honor. So I don't believe he's a flight risk. He does continue to get new charges and return to Walmart. But if the court is inclined to reduce the violation, I would request pretrial services on him and a high signature bond.
The court will grant the defense's motion for a bond reduction. The court will issue or change the bond requirements to a $5,000 signature bond on the felony petty theft and $2,500 signature bond on the resisting officer and stolen property, etc.
And Your Honor,
a total of $7,500 signature bond.
And Your Honor, as to the VOP, would the court impose an additional signature bond on the VOP cases, just so that's clear for the jail?
What's the current?
There is no bond currently.
Is there no bond on those?
Yes, Your Honor. So we're asking for a signature bond on those as well. If the court would
Yes.
Would that be in another $5,000?
The court will issue an additional $1,000 signature bond on each of the VOPs.
So it would be signature 1,000 times 2 for the VOPs.
Correct.
Thank you,
So
Your
it's a
Honor.
total of $9,500.
And he would have to do pretrial services, Your Honor? I'm asking.
I'm not.
Not imposing that. Okay, thank you, Your Honor.
The main thing you just need to do is stay in good contact, make sure you show up, because if not, all
Yes, sir, absolutely. Yes, sir.
Your Honor. Very good. And we'll
deal with the underlying charges.
And we'll make as much progress as we can. If you could keep pre-trial on all 4 of the cases, it'll be April 10 then instead of April 12.
That's correct. Come back on April 10th.
Yes, sir. So,
Yeah.
so signature bond.
Signature bond and everything.
Yes, sir.
Okay? And the amounts you stated, Your Honor, I believe the clerk can provide that to the jail, but we'll go ahead and to memorialize it, submit a proposed order. It may be tomorrow. Hopefully you can get out of jail before then.
Okay.
Thank you.
Thank you,
Yes,
sir.
sir.
And good luck. Make an appointment when you get out. Okay? Thank you, man.
Next will be John Ewing with an E. Ewing. Ewing.
You're on Steve Medina with John Jacob Ewing in 22 CF 2460. Your Honor, we're here for a motion for bond reduction. This is a case that's being handled by Assistant State Attorney Basso. Mr. Ewing has been incarcerated since September 16, 2022. He has a total of $43,500 cash for professional. He's asking for a signature bond. The risk assessment score that was prepared prior to his first appearance did say that he qualified for an ROR or signature bond. There were basically imposed at that time that if he were to get out, that he would have to do GPS and pretrial services. He has no objection to pretrial services and GPS. He did want to be put under oath and briefly address the court, not about his charges, but about his job and need to get out to help keep the roof over the head of him and his significant other. May he testify briefly, Your Honor?
You may. Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Ewing, let me just ask you, what did you want to tell the judge about your need to get out in terms of your job and your residence?
Well, ever since I became incarcerated, it's been hard for my significant other to keep the bills going. You know what I'm saying? I got a senator I take care of, multiple car payment, rent, light bill, water bill. I have a job, I do landscaping. I also provide for my nieces, my nephews. They don't live with me, but they stay with my mom, which is their grandma, and then my sister, which is their mom.
Where do you work?
LaMaster's landscaping, LaMaster's outdoor specialist.
Are you going to be able to get your job back?
Yes, sir.
Okay. Is there anything else you wanted to tell the judge?
No, sir.
No further questions, Your Honor.
What's the state's position on this?
Your Honor, the state's position is, given the nature of the charges, we believe that that is an appropriate amount, that a signature bond is not appropriate. Your Honor, the defendant, if convicted, would score a minimum guideline of 69.53 months in Department of Corrections minimum with a maximum of up to 30 years. He is charged with traveling to meet a minor, using computer solicit, giving obscene material, possession of controlled substance meth that he had on him when he was arrested, and unlawful use of a two-way device. Your Honor, this chat was not isolated. It went on for over a month. In the course of that chat, he went so far as to masturbate live while he believed the juvenile was watching him. So we do have serious concerns as to Mr. Ewing's danger to the community if he is released. If he is released, we would, of course, ask the courts to have the GPS in place, to have pre-trial services, and no unsupervised contact with any minors.
What are the bond on each of the charges? I know it's a total of 43.5.
Yes, Your Honor, I'll look at. I have that. Your Honor, matching it up is a little bit. I'm sorry, I didn't do that in the motion. There's a distributing to minor of obscene material with a $7,500 cash for professional, and if Ms. Basso can help me, I'm not
That's
sure.
count 3.
That would be count 3, okay.
Right.
And then obscene, the use of a computer, that would be 75 cash for professional. I think that would be count 1.
Yes, sir. Mm-hmm.
And then there would be a $15,000 cash professional. That's the traveling to meet. That would be count 2. There would be the drugs, possession of controlled substance, $5,000 cash and professional. That's count 4. I would note that I don't think, I haven't seen it. We got a recent DVD. I don't think we have FDLE. And to address that in a bond, if the court would consider it, he could do substance abuse evaluation and treatment as part of his pretrial release conditions. There was a two-way communication device, $5,000 cash and professional. That is count 5. And then there was a FTA. That was apparently something related to Walton County that had a $3,500. Your Honor, I do think that he possibly could post some cash for professional, could I reopen just for a second for him to just address that with the court? Is there some money that he and his family could put up? Could you address that, Judge?
You can ask him an additional question if you wish.
May I, Your Honor? Thank you. So, could you put up any cash professional, and if so, what amount could you put up?
I think about $2,000.
So you could put out of pocket 2,000, or you could put 200 on a 2,000 total.
2,000, 1,500, 2,000.
What would you put up? So you could do a 20, 15, or 20,000 bond with you could do a 1,500 to 2,000 out of pocket.
Yes, sir.
Okay.
Let me ask a question. Where are we at with this case? We're back in September.
Your Honor, we
at
have
as far
done
as-
depositions in this case.
What's that?
We've done depositions. Mr. Medina and I have done some depositions in this case. There was some additional data that he required as a result of those depositions. We are in the process of providing that to him. So the discovery process is ongoing and case is moving forward.
Right, Your Honor.
I'm asking a little specifically. They're coming back on a bond. How close are we? I understand we're working it. We're always working it.
I think I may address that.
I would defer to Mr. Medina since he has to prepare.
When I got back yesterday from a week out of state, Your Honor, we did receive a DVD during my absence. I did mention that to him, our investigator, and if he gets out, he will be making appointments so we can go over that to see if those are the remaining items. It's possible that we have everything. If that's the case, I'll review that, see if there are any question marks, any need for depositions, but I don't think there will be any problem in being ready for trial this cycle. There's always a possibility there'll be some sort of motion arise or something, but I'm not anticipating that.
Okay.
The state would agree, Your Honor.
And we,
that's good. Ultimately, that's the ultimate resolution. We need to get this case resolved one way or another. Not, a bond hearing is important. I'm not going to change the bond that was set. These are serious charges. But hopefully we can move the case and you can go to trial if you feel like, you're being improperly charged with these things. You have that right. So, for today, the court's going to deny. The court has the discretion. I don't think they're out of bounds because the number of charges and the severity of the charges.
Thank you, Your Honor. We'll see the court on April 12th now. Thank you.
Thank you.
Next will be Castillo, with a C.
Brian Morrow from Mr. Castillo, Your Honor. This is 20 CF 1733 Alpha. This is going to be a negotiated resolution on a VOP, Your Honor. The agreement contemplates that we'll ask the court to reinstate the probation, $100 VOP fee, $150 cost of defense, and reimpose all original terms and conditions, Your Honor. For record purposes, Mr. Castillo is going to have to restart some of his coursework, unfortunately, but he's aware of that and says he's going to be able to get it done.
Okay, very good.
Pause briefly, let my client sign and I'll approach the law.
Very good.
And Your Honor, Your Honor, this is going to be a downward departure. The defendant does 438.4 as a lowest permissible sentence. This is the state's agreement, though. I'm under I'm of the understanding that he did do some of the treatment, which is the main portion of this violation. I'm under the understanding that he knows he needs to start the treatment all over and he needs to attend and complete every session, or the state will be asking for prison.
Can you do it?
Both of this.
Both. I think it's both of this. Yeah. Classes.
Oh, yes.
Right.
Yes.
Well, if it was completed, then it's done, but.
Yeah, the sex offender treatment is open.
May I approach, Your Honor?
You may.
And Your Honor, I have a score sheet printed downstairs that I will present to the court. I believe Mr. Morrow's got a copy of the score sheet before. If you want to show that. And Your Honor, the reason I didn't add extend or modify in there, just so the court's aware, is that his termination date is currently in 2026. So he's still got plenty of time for him to complete the requirements he already has.
So basically, in addition to the fees and costs, we're reinstating, and then all the original terms and conditions are being reimposed.
Correct, Your Honor.
Okay. Mr. I'm sorry?
Is this a new term or just a reinstatement?
Reinstate, just reinstate probation, because it's apparently fairly far out still. Mr.
Yes, Your
Castillo,
Honor.
would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay. So, I'm looking at the plea agreement. You've signed it to reinstate terms and conditions. Pretty straightforward. You believe this is in your best interest to enter into this? You understand this will resolve your violation of probation? Do you have any questions concerning how this affects your legal case? Okay. Based upon that, the court will accept your plea agreement, reinstate probation, some additional fees and costs added on, and reimpose the original terms of the probation.
Thank you, Your Honor.
Thank you.
Next is Joseph Cottrell.
Cottrell.
This is Ryan Morrow from Mr. Cottrell, Your Honor. These are two matters, 22 CF and 22 CF 1848 Alpha.
Yeah, but I've got questions on the phone.
I ask these numbers. Your Honor, we may negotiate a plea on the VOP in both matters. The agreement of the parties is that we're going to ask the court to revoke and terminate the probation, 12.1 months state prison, $100 VOP fee, $150 cost defense, and I have marked on here with all cases and counts concurrent and credit for all time served. Pause, let client sign.
It's a little bit better than 1120.
And for record purposes, Your Honor, this does represent a slight downward departure from negotiated plea.
Thank you. So the state in agreement with this?
Yes, Your Honor. For the plea today, the state is willing to take off that month and some change from his sentence.
So it will be a downward departure based upon the negotiated plea that the defense referenced?
Yes, Your Honor. He scores 13.5.
Very good. Mr. Cottrell, is it Cottrell?
Yes.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So, you heard your attorney state the terms of the plea agreement, and I see the same terms are contained in your plea agreement that's written, which you have signed. Have you read this plea agreement closely? Have you gone over it with your attorney, make sure you had all your legal questions answered?
Yes.
You believe this is in your best interest to enter into this plea?
Yes.
You understand that by entering into this plea, you're waiving the right to go to a trial, to a contested hearing on this?
Yes, sir.
This will be a final resolution of your cases.
Right.
Okay. Very good. Based upon that, the court will accept your plea agreement, revoke and terminate supervision, so probation will be over. Court will sentence you to 12.1 months in the in DOC or in?
It is.
Okay,
I think
because it's
state prison,
12.1.
I'm sorry.
And you will have some fees and costs. You will get credit for all time served. Is this 12.1 for each of the charges?
No, Your Honor, that was on each count, each case concurrent.
You got it, didn't you? Yeah, you gotta put it in there. Okay, so 12.1 on all the cases,
Yes,
all being
Right, it's two
concurrent.
matters before the court, and it's to be imposed on each case and to run concurrent.
Okay. So the 12.1 is going to be imposed. You got 4 charges.
Yes.
Each of the 4 charges, you're getting sentenced to 12.1 months.
Okay.
But they're all served concurrent at the same time.
Okay, so.
Okay, and you will get credit for time served.
Yes.
It will be calculated according to each of the charges.
Yes.
Okay, got it? Any questions?
No, that's it.
Thank you.
Fingerprints over here. Next will be Anthony Griffin with a G. Griffin.
Mr. I wonder, what about 22 CF 2040?
So you have a third matter?
There's 2 cases, but there's only one on the thing sentencing with 4, when I've got a
Did I
total
not?
of 5. There's
May I
also
approach
22.
Madam Clerk? It may have been that. I just thought that case was on the big one.
That one was the vehicle
I'll
theft.
fix that later, Madam Clerk.
Okay, thank you.
Your Honor, this is Mr. Anthony Griffin. He's going to be entering a plea to the bench. We're going to ask the court to set off sentencing. But I do have a plea agreement just for the record. See what the report. Matter before the court is 22 CF 1240 Alpha and 22 CF 2457. We're going to be admitting on the VOP straight to the court and ask the court to set sentencing on that early May date if you do want, Your Honor. May I approach?
You may. Mr. Griffin, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so Mr. Griffin, I'm looking at your plea and sentencing agreement that I believe you've signed, correct?
Yes, sir.
Have you gone over this plea agreement in detail with your attorney to make sure you understand all the legal ins and outs of this thing?
Yes, sir.
And you understand that this is a plea to the bench. You're going to get a chance, you and your attorney, to argue what you believe the plea. Do we have is there a score sheet on this?
So, Judge, I'll provide a score sheet to the court at sentencing. It's important.
I understand that, but he needs to know what the score sheet is.
So Judge, it's interesting actually. There's a 36-month suspended sentence in this case. My initial review of the score sheet in this matter indicates that Mr. Griffin actually scores more than 36 months DOC. Interesting because essentially my understanding of the law, shooting from the hip, is that a suspended sentence acts as a cap for the court. The court can't go above that 36-month sentence. So my anticipation is that the court will essentially be considering a downward departure potentially at sentencing in conjunction with the 36-month suspended sentence, if that makes sense.
Okay, so the score sheet will score out because of the suspended sentence that acts as a cap.
Correct.
So, are you intending to seek a downward departure, counsel?
Yes, Your Honor. He's been approved for rehabilitation facility health project.
No, I'm not asking for details. The reason why I want to ask
I
you
will
the
be.
question, and everybody can hear what I'm about to say, because you're going to be hearing this from other people too.
Okay.
You need to file a motion.
Understood, Your Honor.
It needs to be put on the table, not the day of. You know, everyone needs to lay out what we're arguing.
Okay.
Same as the state is required to do if they want to enhance.
Understood, Your Honor.
Okay? I'm not getting on you. This is just
I understand
want to be
completely,
clear
Your Honor,
because we've
and I
had,
appreciate you letting me know.
not you, but we've had some issues, and if I'm not clear, it's on me. So
Understood.
I'm trying to be clear. It sounds like I'm kind of.
And I'll get out in front of it, Your Honor.
So.
And I appreciate you asking.
So that's important, this discussion with you, because you now know that the state's basically going to be arguing for the suspended sentence, but your attorney's going to be arguing, reduction in the maximum cap that you have. Do you understand that? But you do understand that by entering into this plea here today, other than the sentencing, this will be a final resolution in your case. Are you pleading an adjudication of guilt?
My notes indicate that he had already previously been adjudicated in these matters, Your Honor.
So, very good. But all that's left is the sentencing. You'll be able to argue that with your attorney?
Yes, sir.
But you're not going to be able to, if you don't like what the court does, you're not going to be able to back up and say, I'm going to go to trial on this. That part of it will be over upon the acceptance of this plea agreement. I understand that? Okay. And you have had all your legal questions about this plea answered by your attorney?
Yes, sir.
And you've read through this in detail? Okay. And you believe this is in your best interest to enter into this type of plea?
Yes, sir.
Okay. Do you have any questions regarding this plea?
My only question was the co-terminus thing, because
I can address that briefly, Your Honor, and this was something I was going to bring up in sentencing if necessary. My anticipation is the state will stipulate, but for some reason, in one of these matters, the warrant was served like a month and change after the fact. And the defense believes that Mr. Griffin should be entitled to credit from the service of the first warrant, because I think it was just a mistake. It just sat. It was an Okaloosa County warrant. It was sitting in the Okaloosa County jail. And I think that is what Mr. Griffin is raising. But I can take that up with the state, see if we can seek a stipulation recognizing that error.
Is that going to be something that's at issue in the sentencing?
Your Honor, I have confidence that if it will be an issue, that Mr. Morrow and I will talk about it in advance, and it essentially will, if we're going to argue about it, we'll both be prepared to do so.
Right. Okay. And it's all clearly reflected in the record when it was picked up on the warrants, Your Honor. I don't anticipate that being an issue. It's just from Mr. Griffin's perspective, it is an issue.
Okay, very good. Any other questions?
No, sir.
Yes, we need to.
I mean, I have your date.
When do you want to do the sentencing?
May I have that early May date, Your Honor?
May 9th.
And I want to be
how
clear.
long do you anticipate it takes?
I only anticipating taking a little bit of testimony from my client, and it'll be
So maybe half an hour or whatever.
That's
that's for our scheduling. It's not,
Yes, Your Honor.
we're not trying to limit you. We're
Of
just,
course not, Your Honor. And I just, if I say it, I'm anticipating.
several minutes, sure. We might be able to-
My client's already prepared a statement, and it won't take him long, but that's it.
So we'll come back on May 9th
One,
for the sentence.
I want to be clear about what the court
Yes.
wants in terms of this motion for final departure. I've heard from some of my colleagues that Judge Brown likes a sentencing memorandum. Is that essentially what the court is asking for?
If you contain it in a sentencing memorandum, that would be fine. What I'm interested in is having everybody on notice, including me, because I have to prep for these sentences, to know whether or not you're seeking a downward departure and what is the legal, because there has to be a determination, as you well know, and everybody else in this room knows.
Yes, sir.
There's got to be a determination, does it meet the statutory requirement? And then it becomes discretionary, okay? But I don't like to come in blind. There's a handbook, there's, black letter law handbooks that have hundreds of pages of these downward departures. They're very complicated on occasion. I want to know what it is so I can be well prepared, and also so that the state knows what they're doing, just like you need to know if there's an enhancement.
Yes, sir. Understood.
Okay. But if you do a memorandum, that's fine.
Thank you, Your Honor.
Next will be Schroff Barnes with a B. Barnes, he'll be followed by Mr. Jimmy Case out of the audience. Barnes. Mr. Barnes approaching. He'll be followed by Jimmy Case out the audience.
May I have a moment, Ron?
Sure.
John, could I get Mr. Case up for,
Sure. You want to do this after? Why don't we do it right
I'd
after?
rather go ahead and take care of him if that's okay.
Fine, the podium's being occupied.
Oh, yes.
I can happy to step back, Ron, I'm sorry.
Just step over here.
I'm sorry, Judge, it just
That's
sounded
all right.
like they had to get the paperwork.
That's all right, no, I'm good with it.
Sorry, Judge. Could I get Jimmy Case?
Jimmy Case.
Jimmy Case, Judge, I'm sorry. Thank you. It's 22 CF 1820, and we have an agreement, Your Honor. It's been signed by all the parties. I made a copy on my phone, so if I may approach with the agreement, Your Honor, the state will have a score sheet.
Yeah. We also have a violation of probation, so is that being addressed as well?
I only have the 22 CF 1820. Is it a misdemeanor violation of probation?
Why don't you show that to the state also. Mr. Medina, show that to the state.
Yeah, that's usually, that's in county court, 22 MM 371. Let me show it to the state judge. Your Honor, if I may, we may be able to revoke and terminate. If they're ready to go, we can set him down, Your Honor, and I'll figure this out with Ms. Sharpless. I don't want to delay the court.
Okay. You ready, Ms. Morrow?
Just have a seat.
Oh, yes,
We'll
yes,
clean it up. If
Come on back.
Thank you, Your Honor.
So let me add it. Client model for Mr. Barnes, Your Honor, this is 22 CF 260 Alpha. The case is VOP. This is going to be a negotiated resolution, essentially just asking the court to revoke and terminate the probation and impose a 48-month suspended sentence, credit for all time served, $100 VOP fee, $150 cost of defense, all financials to reduce to a lien 1 year after release. I'll pause, allow my client to sign.
What number is this on the docket?
This was added on, it should be on your add-on docket. I have a copy.
Okay, that's all right.
May I approach, Your Honor?
You may.
Your Honor, I have his number 38 on the docket that I have. That's on
Okay,
page
thank
16.
you. Would you announce, counsel?
Yes, Your Honor, this is going to be a negotiated plea on the VOP. We'll revoke, terminate probation, and ask the court to impose the 48 months suspended prison sentence that was previously ordered. Credit for all time served, $100 VOP fee, $150 cost of defense, all financials to reduce to a lien after 1 year.
Very good. Mr. Brown, would you please, Ms. Barnes, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement.
Yes, sir.
And I see that same terms are contained in your written plea agreement. First of all, have you read the plea agreement?
Yes, sir.
Have you gone over it closely with your attorney to make sure you had all your legal questions answered?
Yes, sir.
There's a lot more that goes into this other than just the terms. You're waiving some valuable legal rights by entering into this plea agreement. You're waiving the right to go to a trial, to force the state to prove their case. You understand all that? You
Yes,
believe
sir.
this is in your best interest to enter into this plea here today?
Yes, sir.
Why are you entering into this plea?
There's no way I can, come out, not getting a lower sentence, so.
Do you believe this is in your best interest to enter into this plea?
Yes, sir, yes.
Okay. And you have had all your legal questions answered regarding this plea?
Yes, sir.
Nobody threatened to coerce you to get you to enter into the plea?
No, sir.
Very good. Based upon that testimony, the court will accept your plea agreement here today. Will revoke and terminate probation. The court will impose a 48-month
the suspended sentence, 48-month suspended prison sentence. You will get credit for all time served. There will be some fees and cost of defense. All financials will be reduced to a lien 1 year after you get released. Okay? Any questions? Thank you very much.
Next will be Jimmy Case with Public Defender's Office.
Your Honor, may I recall Mr. Case? I thank the bailiff for raising the issue. Your Honor, what we've done is we've added to the agreement 22 MM 3711 with a resolution indicated by asterisk at the bottom. And if I may approach with the agreement, then I'll announce the terms.
No, thank you.
Thank you.
You may announce.
Thank you, Your Honor. Your Honor, Mr. Jimmy E. Case is before the court in 22 CF 1820, and the parties have also agreed to address a misdemeanor court case 22 MM 3711. As indicated in the agreement, he has new law charges, a third-degree felony possession of controlled substance and a first-degree misdemeanor paraphernalia charge in 22 CF 1820. He also has a misdemeanor VOP in 22 MM 3711. Under the agreement, and I'm announcing the main part of the agreement as to 22 CF 1820, and then I'll address the misdemeanor VOP. So that in the new law case, 22 CF 1820 of the adjudication of guilt as charged, he will have a 30-month DOC suspended sentence. He will have 1 year community control followed by 1 year of drug offender probation. It says SAET, and he understands that means substance abuse evaluation treatment. The evaluation will be due within 30 days. The treatment will need to commence within 60 days. He will have no weapons or firearms, no drugs or alcohol, $615 in court costs, $100 public defender fees. And then as indicated by the asterisk in 22 MM 3711, there will be an adjudication of guilt, revoke and terminate. That was misdemeanor probation would be revoked and terminated. Time served, $50 VOP fee, $50 cost of prosecution, and $50 public defender fees. And that's the agreement, Your Honor.
Very good. Stated in agreement, yes?
Yes, Your Honor.
Mr. Case, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
May I approach with the score sheet?
All right, thank you.
Thank you.
And the defense is okay with the score sheet?
I apologize, Judge. It's the same one as before.
Yes, and Your Honor, this is a downward departure. He does score 18 months, Your Honor.
And what's the basis?
In the negotiated plea, Your Honor, and that the most concerning priors he has on his record were, they are from 20 or 30 years ago, Your Honor. He has no crimes of violence on his score sheet since those burglary charges on his score sheet.
Very good.
Thank you.
So, Mr. Case, you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement. Have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney to make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering into this plea agreement, this is a final adjudication of this case, it's a final resolution, but you are waiving the right to go to a trial and have the state prove their case beyond every reasonable doubt and all things they're required to do. You believe it's in your best interest to enter into this plea?
Yes, sir.
And the one thing I would say to you is there's a lot of terms and conditions on this one. And you're going to have to pay attention on this one. You've got a 30-month suspended sentence, community control, which I don't like that term. I like the vernacular, the slang, house arrest, because I think it's more accurate. You gotta understand what that is.
Yes, sir.
Because they're gonna be on you, you're gonna have to be reporting. You don't do that, they're gonna violate you, they're gonna be coming in asking 30 months in DOC. Okay?
Yes, sir.
So what I'm just saying to you, you gotta get up every day, you gotta follow through, you gotta be where you're supposed to be.
Yes, sir.
Okay?
And Your Honor, for probation's sake, I did confirm with Mr. Medina before making this agreement that Mr. Case has housing, and I think he needs to give probation that address before he leaves today so they know where you're going to be tonight.
And he's got to go.
Does he need to report today?
He needs to report today.
Yeah.
You're gonna start community control today.
So you understand that? You understand all that? You understand, you've had it explained to you what community control, house arrest is?
Yes, sir.
Okay, and you believe you can do this?
Yes, sir.
Okay. Most important thing is he's your probation officer, and he's to be your new best friend. And by that I mean you need to stay in good contact with him, and then if there's a bump in the road, they'll work with you.
Yes,
If they don't hear from you, they don't know what you're going on, then they don't know who you are. Now, you don't know what matters. They never show up, boom. End up coming back here, they're gonna be asking for 30 months.
Yes, sir.
Okay? So based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on the felony charges, 30 months suspended sentence, 1 year community control followed by a year of drug offender probation, and your substance abuse and evaluation is contained in here and the other costs and fees that are contained. This will also resolve your misdemeanor counts.
Yes, sir.
Okay? Very good. Thank you.
Good luck, sir. Fingerprint? Over here, sir.
Will there is time to pay the probation?
Yeah, there's probation.
No, there's a misdemeanor, I'm sorry.
Oh, yes, Your Honor. Could the misdemeanor cost be transferred to the felony case?
It's up to probation if they want to collect on a county court case.
So the question is, there are a few fees, like a couple, $150 of fees and costs in the misdemeanor case.
Yes, sir.
The misdemeanor case is basically over credit for time served. Can those kind of be rolled over? Because he's got some fees in the criminal case, and so he can pay those while he's on probation in the felony case?
Yes, sir. We could order that he be instructed to pay the outstanding fines from his misdemeanor case during his felony probation
Okay,
case.
so that is so ordered.
Thank you, Your Honor. Thank you, Madam Clerk.
Thank you, sir. Okay. What else we got, Mr. Medina? Is that?
I think that's the business that I'm aware of, Your Honor. Unless my colleagues have any.
Your Honor, the only one that I have left is Bridget Hanshaw.
Which one?
Bridget Hanshaw, this is 20 CF 1885, DOP matter.
Yes.
Yeah. Oh, no, maybe it's Zach's. Is this Hanshaw, is that yours?
Yeah.
Sorry, I don't know.
Another
why
one
I'm
too
thinking
that
of
we had somebody missing, but
It
let's
was
do
Ryan.
Hanshaw first.
Ryan Marvin is Hanshaw, I don't have any information for the court. Your Honor, I've called, there's no one right here.
State?
Your Honor, I'm just gonna look through the record real quick and make sure that Ms. Henshaw would have had notice.
Right now, for the state, it appears that on 2/21, the defendant had phoned in to the state attorney, something about car trouble and their appearance was waived. That's what I have from the last court.
That does appear to be the case. It appears that the defendant would have had notice of the court date today, Your Honor, so the state would request a KPIS.
Court will issue KPIS. No bond. And the final one, we kind of passed over Paris Brown, who has no attorney.
I think, Your Honor,
Is that one that you had, one of his other cases, Mr. Gates? or-
I don't have his other case, Your Honor. He had.
Oh, he
reached
called,
out.
that's right, friend of the court.
Yes, Your Honor.
You don't have enough cases. You gotta handle some that aren't assigned to you.
I tried to, yes, Your Honor.
We appreciate it.
as a friend of the court, I appreciate Mr. Gates doing that. I've represented him in the past. I guess hopefully he'll be here this afternoon. I think that was the expectation.
I passed the message to get here as soon as he could.
And we.
Okay, I'll generous move here. We'll pass over him. If somebody will remind me of his case in the afternoon, so we don't at least address it, because we need to get it set and whatnot. Very good. I appreciate everybody's hard work this morning. Anything else that we need to do before? We'll come back in an hour. Won't take. We'll start on time this afternoon. I know we've got some couple of significant cases.
And that, Coach, it has nothing to do with anybody else here.
You may.
Part of the legal profession.
Who?